Boom. Hey, folks, maybe I should have some light on me, even though it's going to be a warm day. The light's going to make it a little warmer. So, we got a couple of days to catch up on, and I'm just going to warn you, it's going to be a little bit rough because I spent the entire morning off doing a fairly contentious kind of hearing. And so that is that kind of meant that I was playing catch up, but I had people say, "Hey, please do a stream tonight anyway," and I was like, "All right, we'll make it happen." So we're gonna do it. We're gonna go through everything. We're gonna talk about it because there's a whole bunch that happened. Somebody said, "Hey, you're not in jail." I was not really at risk of being in jail, so did I make the crown cry? That doesn't really happen typically. And I'm gonna be, I'm gonna say something that might sound a little weird. I generally get along with opposing counsel, and opposing counsel, despite the fact that he's opposing counsel, and therefore we disagree on what should happen. Is actually a pretty solid guy. I kind of like him. I'd go for a beer with the guy, even though we disagree with him. Looks like I have a mullet. I do not have a mullet. I just have not cut my hair in forever. Okay, so we have 2 days to catch up on. Thankfully, the 2 days are not so bad for catching up on. The first day is day 27. And you might have already seen some of this on other channels. That's fine. We're going to go over it a bit as well today. So what happened is defense wanted to tender some experts. And there was argument. Prosecution wants to keep these experts in. Now, spoiler alert, these experts are going in. Like the prosecution was like, nope, I don't want them. And didn't you say you were going to get a haircut this week? I did, and then I haven't gotten a haircut yet. So you see how that's going. So, yeah. Not weird for the criminal bar. I genuinely like prosecutors and defense counsel. Family law bar, though. Let me tell you a story about the family law bar, or at least one lawyer. I have done very little family law. Very, very little. But I did a file that was I did a file that was a sort of protection hearing, and all hail Runkle of the Bailey, king of the lawyers, maker of hot sauce, and first of his name. Well, thank you, Court TV. So I did a protection hearing where ultimately I'm there and this family lawyer is there. She's on the other side. And she says, "Hey, can I talk to you before we proceed?" And I thought, oh, good. We're going to be able to negotiate this out. There's room for us to come to an agreement. We'll just come to an amicable dispute, like an amicable settlement, that's sort of between the two positions, and everything will be fine. Well, that was not at all what she wanted to do. Instead, what she wanted to do was she wanted to curse me out for having the audacity to oppose her client's position. And I was just stunned because I kind of assumed that, like, as a lawyer, she would understand that we're both just lawyers. We're both just representing our clients. But nope, she wanted to tell me that I was an awful person for daring to represent this terrible guy. Well, as it turned out, we won the hearing. The court did not find that there was my client was a terrible guy. They found that my client was actually the wronged party, and that the whole protection order was brought for bad purposes, for improper purposes. So I won the hell out of that hearing. Now, the courthouse, like the family lawyers, are typically on a different area than the criminal lawyers. But every time I ran into her after that, she literally hissed at me like a cat hissing at you. So, like, literally, like, hissed at me in the hallways. And so, yeah, family law was, that was my sort of dabbling with family law and family lawyers. And I was just like, you know what? Peace out. Like, I don't need that. That's just weird. Meanwhile, in criminal law, there's a guy who I go visit, we hang out, even years later, because he was the prosecutor on the opposite side of a really contentious file. There was allegations of police misconduct. There was, all sorts of things. We were at each other's neck in court, and then we were just peaceful. Like, after we had this really contentious day in court, he was like, you want to grab a beer? I was like, yeah. So we ended up like grabbing lunch during this trial. We ended up, so that's the way things should be, where opposing counsel aren't jerks, but it isn't always the way it is. All right, let's dive in here. Now, we got 3 witnesses to cover today, and it helps if I actually share the screen. The blue is lovely, but it's not what you came here to see. So, and people were asking how my court date was. The decision is reserved, so I don't know what the verdict is. We will find that out later. All right. So here, this will also help, by the by, if I unmute this particular tab. I had that tab muted so that I could adjust it, and now that's not helpful. Okay, let's roll.
Understanding. We started to say it at sidebar the other day.
I do not think Jackson and Lally are having a beer together after this. I think Jackson and Lally genuinely hate each other, and that's fine. I will say that there are some prosecutors who I don't care for. I'm not going to name them, and nobody's ever like done me really dirty, but there are some prosecutors who I really did not like. And so that is a thing. It's sad, but there's nobody who I'm like, who's like really on my shit list, if that makes sense. They're just like, I don't like them. They're too aggressive. They're too whatever. So, okay, carrying on.
And you said you wanted to put that off to get to the witnesses. But I need a little bit of an understanding of what the court's expectations are. My understanding of voir dire, which this.
Okay, so here's what Jackson is trying to figure out. Basically, he doesn't want to give Lally 2 kicks at the can. He doesn't want to give them 2 shots at cross-examining his witnesses. So fair enough. I wouldn't want that either. But he's going to lose because this is the court's remedy for the late disclosure. That's kind of their remedy there. Let's roll on.
Seems a little unusual in terms of the timing of it.
So the understanding of the voir dire is this is for the Commonwealth's motion to exclude this testimony, right? That's what we're here for, the Rule 14 violation.
Is that the same?
So I'm taking this up to 1.5 speed just because we are.
With Dr. Wolf and Dr. Rentschler.
Well, I thought that would help both of you. The Commonwealth has nothing on that, and you say you haven't been able to even talk to them at all about this case.
That's right.
So I want to find out if they have any credible, competent evidence to put forward. So we'll have a voir dire on them as well. But for Dr. Russell, what we're doing here today is there's an alleged there appears to me to be a violation of the reciprocal discovery obligations of defense counsel regarding Dr. Russell. So let's hear from her today to see what the appropriate remedy is for this violation.
So my intention is to ask her so I have, the court understands my sort of guardrails. My intention is to ask her what her qualifications are, which is that's the basis for voir dire. And that's where I'm going to stop. I'm not intending to ask her what her opinions are, conclusions. I'm going to ask her to come to opinions and conclusions, but I don't have to examine her concerning her full opinions or full conclusions, what she's based those conclusions on. It's unfair. We've provided the defense the prosecution, everything that we need to provide to them in terms of disclosure. They've got the equivalent of a report. They've got a summary of what she's going to testify.
When was that provided? My order was 1 week from the start of trial, right?
But we didn't, Your Honor, in fairness, they didn't even finish their discovery 1 week before the start of trial. So it's a little unfair for us to be put on.
1 week from the.
So what he's saying is, I don't want them to be able to like really dig into her and rip into my witness before they're qualified. It's not fair. The judge is like, is it though? I don't know. I don't like it. and I know a lot of you don't like it either, so you can sort of judge for yourself there.
Filing of the certificate of compliance.
Well, I don't know when I can't remember. My co-counsel indicates it was the day before trial.
Okay.
So during the course of the trial is a dynamic thing. During the course of the trial, I did not know who Dr. Marie Russell was at the time that they filed their certificate of compliance. We then attempted to and did give them the reciprocal discovery that we were obligated to do after they filed their certificate of compliance.
When?
Within 3 days of that. We had been giving them information prior to that, but at least within 3 days of that. We've continued, so the record's clear, we've continued to get additional discovery from the Commonwealth and notices of discovery throughout the trial. They have not finished. In fact, during the trial, they interviewed Jen McCabe, apparently, had a full interview with her. Lieutenant Tully took a report, dated the report, and then they held on to that report until after she testified. The interview, the report.
That, to me, is egregious. Did you hear what he just said? During the trial, they interviewed Jen McCabe. They took a report from that interview, and then they didn't hand it over until after she testified, notwithstanding the fact that I bet that report would have been useful for a cross-examination. How do you cross-examine them? Like, you have to rely on information that might be available. Yeah, it's tough.
And the completion of the report were all done before her testimony.
Do you need to call her again?
Your Honor, that's not my, and I think the court understands that's not my point. My point is not I need to call Jennifer McCabe back. I've done the damage that needs to be done on Jennifer McCabe. The point is,
I've done the damage that needs to be done on Jennifer McCabe. I love it. Now, this is not in front of the jury, so he's going to be able to get away with that. But yeah. So she's basically saying, if you want, we can bring Jen McCabe back. We can you can cross her on that new stuff. But he's like, nah, I think she's already dead. She dead, Judge. She dead.
I missed that. You've what?
I've done the damage that needed to be done on Jennifer McCabe. I don't need to call her back. The point is that what's good for the goose is good for the gander. The Commonwealth doesn't get to stand in the position of piecemealing and feeding us information, reports, discovery, seminal information about an expert that we did not know about, never met, never heard of. Within 3 days of that, we provide everything that we have about that witness to the Commonwealth. They can't then turn around and say, oh, well, it's all the defense's fault. So we want to have a voir dire, which means that the euphemism for that voir dire is we want to have two bites at the apple.
Okay.
We want to be able to completely cross-examine her, then go back to our expert, and if she testifies, cross-examine her again after consulting with our expert. That's two bites at the apple, and that's not fair. If the court wants to hear whether or not Dr. Marie Russell is qualified
I agree with him
to
on
testify
this.
about the arm injuries, that, I believe, is the parameters, the proper parameters of the voir dire, and that's what I'm prepared to do today. But I wasn't planning on of her testimony because that's been provided.
I don't know why, but somebody's leaning on the mute button.
The substance of her testimony because he knows what the substance is because, like I said, that's been provided.
All right. So I disagree. I'm going to hear from the Commonwealth on this. Is it Ms. McLaughlin or Mr. Lally?
She's like, I disagree, but I'm going to hear from the Commonwealth. Why are you going to hear from the Commonwealth if you already disagree before Jackson has finished? So, okay.
Your Honor, just briefly in regard to what counsel was referencing with Ms. McCabe, it was not a full interview by Lieutenant Tully. It was a, and I don't have it on me at this moment, but I can give the court a copy of that report. But essentially it was Ms. McCabe met with Lieutenant Tully, looked at some video, and was asked a single question. That report wasn't available. I didn't have it until after Ms. McCabe testified, but it was given to counsel prior to Lieutenant Tully testifying, and there were no questions asked of Lieutenant Tully in regard to that.
Okay, so it was, that's still a concern. Like, if the prosecutor didn't have it before, like, they should have, right? So, yeah.
My issue, and I wasn't asking for a voir dire as it proposed to, as it relates to Dr. Russell, is that we first heard of Dr. Russell on May 21st, which was, I think, 6 weeks into trial.
Right, so that's what I asked, and you told me it was 3 days after the beginning of trial, Mr. Jackson.
No, I said this to sidebar the other day, and I just said it again today. I let the Commonwealth and the court know about Dr. Marie Russell 3 days after I learned about her.
I hate whoever's
I never
hitting
heard of her. I
the
didn't know who she
mute
was.
button in this.
We made contact. I determined that she would be useful for the jury in terms of specifically the injuries to John O'Keefe's arm. I didn't have one conversation with her. Then immediately, within 3 days of that, turned that information over to the prosecution. So I didn't say that I gave this over 3 days of the trial. That's not what I said.
All right, but you were ordered to do it. Ms. Giannetti, what was the date? You had 1 week from when?
The day before the trial. So we're going to, I believe, April 15th. So what we knew as of that date, you were required to turn over.
All right, I need to take a quick recess.
What? All right.
All right, so she's taking a break. She's gonna come back in a few. We're gonna skip over the recess. Ah, stop with the thing. No thing. No, that's even worse. That is even worse. All right, let's try to fix this. It's like, no, stop with the wheel of death. And it's like, okay, well, we'll just. All right, there we go.
Never mind.
There we go.
Paper 360.
I've got it. All right, so the Commonwealth has moved that I exclude
Oh, hey, Rob.
the testimony of Dr. Russell
There's
based on
a
violation
setting.
of the reciprocal discovery obligations of the defense. So I do find that there's a violation of the reciprocal discovery obligations of Rule 14.
Thank you, Rob.
Quoting from the notes, the importance of this, the reporter's notes to the old rule, and as you all know, we're in the process of updating that rule, but the very integrity of the judicial system and public confidence in the system depend on full disclosure of all the facts within the framework of the rules of evidence.
Now, I find this bizarre because here in, Canada, we don't have a reciprocal disclosure requirement. Like, if I find out something other than experts, I do have to disclose expert reports. But if I find out something, I get to hang on to it. I don't have to turn it over to the prosecution. So I can just surprise. The thing is that it's not, you might say, oh, is that unfair? Well, no. How do I find out about things? It's typically via my client, but also, I never have the resources of the government to explore things, right? I can't send 20 cops to go interview things or to go interview people. And frankly, my client is, my client's got rights that the government doesn't have. So, yeah, I don't like the reciprocal disclosure requirement, but all right, carrying on here.
Ensure that justice is done, it is imperative to the function of courts that compulsory process be available for the production of evidence needed either by the prosecution or the defense. So what we're here to do today is decide a remedy for this violation. And that's why we're having a voir dire. I'm not prohibiting the Commonwealth from anything on their examination of witness, Mr. Jackson. The alternative is she doesn't testify. So the Commonwealth has not received the appropriate discovery from this witness. So we're going to have a voir dire, and they can ask her anything that they think they need to ask her. So those are the
So basically, she says prosecution gets everything they want on this voir dire, but you still get to have your witness in. And somebody says, is this quiet for anyone else? It is. I don't know what was with the audio on this particular occasion, but we are going to crank it a little more. And then suddenly it's going to blow out our ears later because they're going to fix the audio after that. And we'll deal with that when it comes. But
emerges of this minute.
As long as I know the guardrails, that's fine. I just to close the loop on the record. My understanding is, Bill can probably speak to this more intelligently than I can, but during the middle of trial, there was a witness that we had never heard of, we did not know, and didn't have a report for.
Who is that?
Dr. Fowler, F-A-L-L-E-R.
Okay.
If the court remembers, he's buried in the middle of about 75 witnesses. So he testified to.
buried in the middle of about 75 witnesses.
Protocols at the institution at Good Samaritan. And we didn't have that information either. We didn't throw a fit. They said we were going to provide this information in a timely fashion as soon as we know they were going to call.
The thing is maybe you should have thrown a fit. Maybe they would have. So I don't know. I suspect they didn't throw a fit in order to help get their witnesses in here. So, yeah.
On our witness list, we didn't know one way or the other what he was going to say. We didn't have a report, and we went on about our business. That's what we were doing as well. And by the way, I would note that the notes and report under Rule 14 require disclosure of information you have. I just don't want the court to think that we were sitting on information that we didn't turn over.
No, I'm not saying that. It's just, this isn't as if it was something that the Commonwealth brought up and you needed to scramble. This is entirely of the defense position. So,
I understand.
all right, so that's the big difference. So why don't you go ahead and call her?
Okay. Yeah, I have the excuse to call her.
Yes.
All right, so now they're going to bring her out. All right, so you can already see one thing I'm just going to note about this witness is that she is going to be inherently sympathetic. Why is she inherently sympathetic? Well, because she looks like, she looks like she's going to come out and open up a tin of cookies. I've slowed it down to 1.25 because it's harder to hear right now. So we're down to 1.25 from 1.5. So she looks like a kindly old grandma who's and yeah, the volume is even lower because the court keeps. I don't know why the court keeps doing that. We've got it up to 400%. And then eventually it's just going to blow out my ears. But that is what it is. Yeah, she looks like she's going to pull out like the best ginger snap cookies like you've ever had.
Rentschler, you solemnly swear you understood the court case now here to the truth, the whole truth, and nothing but the truth, so help you.
I do.
Good
Morning.
I'm going to ask you to keep your voice up. Speak right into that microphone, doctor, okay?
Court, I'm going to ask you to turn the volume up.
Yes.
Thank you. All right, go ahead, Mr. Jackson.
Thank you, Your Honor. Good morning. Could you please state your name and spell your last name for the record?
Yes. Marie Russell, Russell.
And I'm going to echo what the court just indicated. The air conditioners are on, so please keep your voice as elevated as possible and maneuver the microphone however you need to, okay?
Okay.
Dr. Russell, what do you do for a living?
I am a retired emergency physician and forensic pathologist.
And tell me what education you have.
So one of the things you'll be seeing on Twitter from people who are upset is that they are really annoyed that she is retired. They're like, how dare she, she hasn't been, in the game for a while. And I'm like, yeah, okay, fair. Maybe there's some new developments that she's missed out on. But I don't think that they have invented many new dogs since she was in practice, right? Dogs are pretty much dogs. They might have, I don't know, are they still inventing new dog breeds? So, like, dog bites is dog bites. And it doesn't look like she's lost her, doesn't look like she's lost anything. So,
Going all the way back to the beginning, it qualifies you as an emergency physician and former pathologist before you retire.
Okay. Well, I've had about at least 16 years of formal education beyond high school. Initially, I started at MIT, where I did my pre-med course.
wait a minute. You're going to tell me that you are not at like 120 hours into a course, but instead that you started at MIT? Like, she's like, let me tell you the story of 16 years of formal education, and it begins with MIT. So this is going to be good.
Because I had always wanted to be a physician, and so I went to MIT for a year, took pre-med courses, and then I had an unusual life event in that my mother came down with cancer, and she subsequently passed away. During the time away, so I took some time off from school. During that period of time, I decided to explore another interest of mine, which was law enforcement, and so I took some courses in law enforcement. And I became a full-time police officer here in Massachusetts.
What years were you at MIT?
That was 1972 to 1974.
Did you go to the police academy?
I did. Once I became a police officer here in Massachusetts, I attended the Boston Police Academy where I graduated.
What year was that?
Now, I'm just going to say, when she was younger, I bet she was a badass. But right now, all I can picture is like, police grandma, and I feel like this needs to be like a comedy where like grandma police officer has taken down the bad guys. So that's just the image that's stuck in my head, and yeah. my head is sometimes a weird place, but I would totally just pay to see her starring as a police officer, just, quietly taking people down. But yeah, so she started out as a female cop like 20 years ago or something, and that's got to have been an adventure. That's got to have been impressive. So let's keep going.
That was in 1977.
During the course of your training as a police officer, did you have
Sorry, not 20 years ago. Many years ago, 50 years ago. Shit.
any specialized training in hit and run accidents and investigations?
Yes, I did.
And which agency did you work for as a sworn peace officer?
I worked for the city of Malden full-time for 7 years.
That would be from 1977 to 1984, approximately.
Correct.
During that time, did you continue your education in any way?
I did. So I took as many courses as I could from the Massachusetts Criminal Justice Training Council.
120
which included
hours.
A course, a several-day course in hit and run accident investigation. I took courses.
So she took the course that the Trooper Proctor or Trooper Paul took, and that's only just as an aside, it sounds like.
In forensic photography and numerous other things. And then, and I also at the same time continued to go to college. And I did that part-time where I eventually got a bachelor's degree of science in psychology with highest honors.
What institution was that from?
That was from Northeastern University.
And that was a bachelor?
So she's working full-time as a cop, and then she, on the side, goes and gets a highest honors psych degree.
Of arts and psychology?
I think it was a Bachelor of Science.
Got it. Subsequent to your Bachelor of Science degree from Northeastern, did you also advance your education further, formally?
Subsequent to, so yes, so I decided that I did want to pursue a medical career. And so I then attended medical school, University of Massachusetts Medical School full-time for 4 years.
Did you ultimately get a degree, an MD degree from UMass?
Yes, a Doctor of Medicine degree in 1987.
So you were there from...
So then she's like, well, I'm a cop, I'm a psychologist, I'm gonna become a doctor too. Like, we're just gonna, I mean, I feel like she needs like a special reinforced wall just to hold up her degrees here.
1983 to 1987, is that right?
That is correct.
And did you do a residency?
I did 2 residencies actually. Most people do 1, but I did 2.
Finney's wrong.
I did, my first residency was a combined internship and residency for 4 years. And I did that in Los Angeles at Los Angeles County Medical Center, which is a very big trauma center and what I would consider the Bellevue of the West Coast. Very busy.
You say that just because of the volume at USC Medical Center?
That is correct.
Is it one of the busiest medical
Oh, fair.
centers in the country?
She's got a
Yes.
psych
You were
degree.
there from 1987 to 1991, is that right?
I did my ER internship and residency during those years. Yes, there.
During that time, were you seeing patients?
Oh,
You
yes,
were treating patients?
lots of them.
You were attending to patients?
I was a trainee, so I was seeing as many patients as we could. There was always a waiting room full of patients, and yeah, so I saw many patients during that time period.
You indicated a second residency? Tell me about that.
Okay, so
All right, and then the audio suddenly, my earballs. So we're just gonna tone that back down because that suddenly kicked in with some force. It was like somebody's describing her as real life Barbie because she's got like all the it's like police officer Barbie, Dr. Barbie. Yeah.
still realized I had an interest in forensics, and so I decided that I wanted to also train in forensic pathology. So I did a second residency in anatomic pathology, 2 years, followed by forensic pathology fellowship at the Los Angeles County Coroner's Office for 2 years.
And the years, if that's 4 years, that would be from 1991 to 1995, approximately?
That is correct.
But do you have
Tell
an
me what your
associate's degree?
experience was as a fellow at the Los Angeles Coroner's Office, Los Angeles County Coroner's Office.
Yes, well, it also was a very busy coroner's office, and so every day there would be cases. I probably did at least 2 cases a day, most days, and plus conferences, and educational opportunities. But the interesting thing about being a fellow is they try to give you a wide assortment of cases. So, for instance, I not only saw numerous victims of gunshot violence and stabbings, but I saw numerous victims of motor vehicle accidents and natural death, overdoses. And then if there was an unusual case, it usually went to the fellow, because the fellow was also being supervised. So
Did any of those unusual?
So basically, she's like, I got to do everything. And I don't know if she is a beer person, but it seems like it would be amazing to just sit down with her and have a drink. I kind of feel like maybe she's more of like a sherry person or like a brandy or something like that. But I would love to just hear her stories. Like this is fun.
Unusual cases, and we'll get more into this in just a second, but did any of those unusual cases include animal attacks?
yes.
Did you become a professor, an educator at any point?
Yes. So during my 29 years at LA County Hospital, during the last 25 of those, I was a assistant professor or an instructor, but mostly an assistant professor. And what that meant is that I was responsible for overseeing the care that was provided by the interns and residents. So when a patient would come in into the hospital, the emergency room, they were oftentimes usually seen by the intern or resident, and then I would go and subsequently see that patient also. So, and that was in addition to my own cases. So I'd see my cases and their cases.
And that was at LAUSC, correct?
That is correct. And
Can I ask a quick question?
Yes.
LAUSC, for those of us who are not necessarily familiar with it, is that associated with the University of Southern California Medical Center?
Yes.
That's the school, in other words, the site.
Yes. So it stands for Los Angeles County / University of Southern California Medical Center.
And that's where you were an assistant professor for the majority of the rest of your career.
Correct.
Were you also an assistant or an adjunct professor at Cal State Los Angeles?
Yes.
Okay. For how long were you an adjunct professor there?
I believe that was
Okay, for all of us who like struggle with imposter syndrome, she is like the end boss of imposter syndrome, because after listening to this, it's like, oh, well, I suck. She's I'm just like, oh, well, I'm just a lawyer. Crap. I guess I get better go become a doctor and a cop and a astronaut if I want to keep up with her. So
4 or 5 years, and I taught criminalistics, forensic medicine there.
As an attending physician in the ER, in other words, a supervising physician in the ER, can you tell us what some of your duties and responsibilities included, especially as it pertains to trauma? And then I'll get more specific in just a second.
Okay. Well, so I would oversee the care of all the patients that came in during a particular shift. And that would include medical patients and trauma patients. And as I mentioned, it was a very busy trauma center. So we had lots of trauma patients, including the types of violence I described earlier that I saw at the coroner's office, but lots of motor vehicle accident victims, because there was a highway there right nearby. There were a couple of highways, so a wide variety of accidents.
Did your supervision include assessing, diagnosing, and treating patients?
Correct.
In terms of the middle part of that.
all right, we're gonna skip through some of this, because if we go over her entire qualifications, we're gonna be here all night, because her qualifications are basically like, the entire trial. So like, she just keeps going on her qualifications. She is so bloody qualified. It is nuts. Okay, so let's jump ahead a little bit. This is the kind of expert that you hate seeing the other side bring out, because it's like, I'm going to challenge this expert. Oh, right. She knows everything. Now, you know what's really awesome? We're going to hear her qualifications again, because none of this was in front of a jury. So now in front of the jury, she's going to go through all of this a second time during the defense's case.
Yes.
Exhibit 2 for voir dire.
Yes.
I have not seen Legally Blonde yet.
Is this a photograph of the John O'Keefe's arm?
Yes.
Is this one of the several photographs that you reviewed in coming to your opinions and conclusions?
Me too.
Yes.
I want to ask you a couple of questions about this. There should be a laser pointer on the desk.
Okay.
Can you explain for the jurors what it is about the injuries that assisted you in coming to your opinion and conclusion that this is from an animal attack?
Okay, there's several patterns here. So, for instance, let's look here, right near the elbow, the exterior part of the elbow. There's these 2 linear marks, which appear to be from upper teeth, and 2 punctures below those, which are superficial, meaning they didn't go very deep into the skin, but they appear from the lower teeth. So that's one pattern.
All right. So this I thought was really interesting because there's a lot of people who are like, how can it be a dog bite when there's no lower teeth? And the thing is they're wrong, right? They're just wrong because you can see these D's at the bottom are the lower teeth. That's what she's saying. Now, here's the other interesting thing. The prosecution's theory is that this was caused by a broken taillight as it passes, right? Now, I've got a question for you. Like, I can see maybe a broken taillight causing the initial injury, right? But then how does the broken taillight stop slashing and then start slashing again, right? It starts, stops, hole. How do you explain that second hole if it's like, because that's something biting down, right? That's something gripping in. And unless this tail light is somehow, om nom nom, I don't see it. So, yeah. I just don't see it. It just makes no sense to me. So, carrying on here.
Pattern. There's another pattern close to the shoulder, which shows parallel marks. These 2, and maybe a third one in the middle, parallel marks that are oriented at a certain angle, and these are superficial wounds, which are consistent with teeth marks. They also could be possibly consistent with nail marks, but
With what?
Nails from claw. Yes.
All right.
All right. So one thing I'm going to mention, I saw it in the chat. I'm going to comment here. They're saying like, this doesn't seem like a grab and hold. It may not be a grab and hold. It may be a police dog that doesn't know how to grab and hold properly yet. So now I thought it was interesting that she says that these are teeth marks, the thing that is right where my face is. Why is my face blocking the things? She says these are teeth marks. Okay, I thought claw marks. But she says more likely teeth.
We have some more here, similar from obviously different teeth involved or different claws, and then down here closer to the wrist, we have an unusual pattern of at least 4 striations, the way I see it, at least 4 striations that I believe are caused from the teeth towards the front of the mouth near the arch. It appears that there's an arch pattern here. So,
in a dog attack or in an animal attack, in your experience, who can take this one down?
Now let's talk about dogs and really canines in general. We teach police dogs the grab, bite, hold technique, right? We teach them to do that. But what do like dogs and wolves and so forth do in the wild? Well, they're pack animals, right? They're pack animals. And yeah, a police dog trainer said failure to grab and hold is one of the primary reasons for washout. Dogs don't inherently want to bite humans like that, apparently. The thing is that dogs in the wild, so let's say you're a deer, right? And you're about to have a really bad day as a deer because you have just run into a pack of wolves or a pack of coyotes or a pack of some similar canines. Well, what do they typically do? They run an animal down and they harry it. And what I mean by that is that they'll snap at it repeatedly and sort of shred its back legs. And it's really an ugly way to go. Animals are jerks. You know, they'll grab and rip, and they'll sort of rip parts off until eventually the animal can't run away anymore. Some dogs, typically dogs that we have bred for this purpose, are better at grab hold, like pit bulls and so forth. But most dogs kind of grab, rip, and, you know, so this looks, yeah. But these look like dog bites to me, so much like dog bites.
Let's cover the ground on the 3 exhibits that we've already marked. Can we take a look at Exhibit 1? Is this just a may I publish, Sharon? Yes, I apologize. Is this just a close-up of the same injuries?
Yes.
And do these appear to be consistent with what you just testified to in terms of either teeth or claw marks, especially as it relates to the area closest to the elbow?
Yes.
All right. And then looking at Exhibit 3. May I publish?
Yes.
Is this a close-up view of the area closer to the wrist that indicated those parallel, you used the word striations?
Yes.
All right. And these appear to be taken, attended to the autopsy as opposed to the other photograph, Exhibit 2, that was taken in the hospital. Is that right?
That is correct.
All right. And would the time difference account for the slight change in the nature of the wound?
It could.
Photograph of the wound, I guess?
It could, or a different technique, yes.
Okay. Let me take these down. Did you take into consideration the lack, in coming to your opinion and conclusion, the lack of other injuries, for instance, fractures, broken bones, or deep bruising, soft tissue injuries?
Oh, yes.
How did that play into your opinion?
Well, so of course I considered, you know, what else could have caused these wounds, you know, before coming to my conclusion. And so I wanted to rule out other things. And there were no significant major bodily injuries that, outside the head. There was nothing, there were no fractures of the long bones, the chest, the pelvis, you know, the arms. So, yeah, so.
Wow. This is a facial expression. This is interesting. And I don't really like zooming in on the family, but
the chest, the pelvis, you know, the arms. So, yeah, so having seen hundreds and hundreds of car accident victims and people hit by cars, I ruled that out very quickly.
Okay. And in terms of the injuries that you did see, especially as they're...
He's not happy. And so I've seen some people saying, oh, you know, maybe he's come around. I don't think so. And I don't think he owes anybody that, right? He's allowed whatever feelings he wants. And, you know, he was owed a better investigation than he's getting. But, yeah, I feel bad for him. This has got to be the worst. This is the worst thing to ever happen. Like, this is so unfair. And,
attendant to the arm. Based on everything that we've discussed today, is it your opinion, based on a reasonable degree of scientific certainty, that those injuries are consistent with an animal attack as opposed to a motor vehicular pedestrian incident?
Yes.
Thank you. That's all I have.
All right, Mr. Lally.
Good morning, ma'am.
Good morning.
Let me take you back to, you were talking about some police training that you had received when you were in the academy or while you were working with the police department here in Massachusetts. Is that right?
Yes.
Okay, what kind of training or what did that training consist of?
Well, I attended and graduated from the standard police academy at that time. And And then I took additional courses that were offered from the Massachusetts Criminal Justice Training Council. And these were taught generally by experts in their fields. And they were on a variety of subjects that are listed in, in my CV, including, the hit and run accident investigation, forensic.
There, just for a minute, ma'am. Doctor, in reference to your training as it pertains to hit and run accidents, what did that training consist of?
Oh, well, mechanisms of how accidents occur, mechanisms of how to determine, what vehicle was involved in an accident. I don't, it was a long time ago, but yeah, so determining if people were struck by vehicles, what vehicle was involved, or if there was auto versus auto accident, what vehicles were involved.
And I don't mean to belittle this training whatsoever, but is it fair to say that was relatively rudimentary training that you received in the academy?
Probably. I would not. Yes. Okay. Probably. If
Okay, let's stop there. Would it be safe to say that it was relatively rudimentary training you received in the academy? Lally, the training she got that she's describing as, yes, it's relatively rudimentary, is basically what your expert, Trooper Paul, got. So, that relatively rudimentary training is compared to, the degrees she's collecting, to, wallpaper her wall with degrees. But she considers that rudimentary next to med school and getting top honors in psychology and so forth. So, Lolly, maybe don't throw any shade, because when she's saying it's relatively rudimentary, she's still ahead of your expert by so much.
Training in crash reconstruction or anything like that, correct?
that is correct.
And am I correct? And you indicated that you're board certified in emergency medicine, is that right?
That's correct.
And so you're not board certified in forensic pathology or anatomical pathology or any kind of pathology?
That's correct.
And the last time that you worked as a coroner, when was that?
Last time was in 1995 when I was doing autopsies for the coroner's office. I have since, though, consulted on some cases from the LA coroner's office.
What, about 30 years ago? Is that about right?
For autopsy, yes.
Now, have you ever testified in a case in which either Mr. Jackson or Attorney Little were counsel?
Not that I'm aware of, no.
And when was it that you first were contacted in reference to this case?
The first contact was May 15th.
May 15th of what year?
May 17th, excuse me, of this year, 2024. Yes.
And you went through a list of things that you were providing and you reviewed, and you mentioned hospital photos, correct?
Yes.
Autopsy photos, is that correct?
Yes.
An autopsy report, is that correct?
Yes.
Grand jury.
All right, so this is going to be interesting because there's some stuff that she's going to say no about that is kind of interesting. Some of it, and the defense is going to be like, we sent it to her. We don't know why she didn't look at it. That's weird.
Testimony from the medical examiner, is that correct?
Yes.
A neuropathology report, is that correct?
Yes.
A toxicology report, is that correct?
Yes.
And then I think you also remember some photos of some clothing items, is that correct as well?
Yes, a shirt. And
Anything else?
yeah, hospital ER record.
Hospital ER records.
Yeah, yes.
Anything else that you can think of?
No.
Did you ask for anything else to review?
No.
Were you told of any other material that was available for your review that you weren't then given?
Well, I requested that that I focus in on the wounds, so I didn't ask for a lot of material in this case.
But fair to say that you were looking for anything and everything, material to the wounds that you were asked to look at, correct?
Please say that again.
Sure. Fair to say that you would want to look at anything and everything that was related to the wounds that you were asked to look at, correct?
Yes.
And so, did you make any specific requests as to what material you were provided, or were you just handed some material or forwarded some material and you looked at what you were given?
No, I requested that I have the autopsy photographs, the ER records, the ER photographs. I requested those.
Now, you mentioned some articles that you had written that were published back in 1996 and 1997 related to dog bites. Is that right?
Yes.
Are those publicly available articles?
Yes.
And
She's like, yeah, that's what published means. Like I'm a published author. Like, okay, we're gonna skip ahead, I think, to the end of her. Lolly goes for a while, but then we're gonna get to some of the we're gonna get to the argument at the end, because this is Lolly's this is their argument to exclude, so we're gonna jump to that. All right, here's her heading off the stand. He's telling her, go find an office, wait for me there. I will come chat with you afterwards. That's what that discussion is right there.
So I would like to hear argument on this witness before we hear the other witnesses. So, and Ms. Giannetti, I asked you the other day whether she reached out to you or you reached out to her, and you said there was an intermediary. But my concern was whether she came out of nowhere and reached out about this case. And that.
So why is the judge concerned that the witness might have reached out of nowhere? Well, the courts don't like busybodies, right? The courts don't like people who want to interfere, right? They want an expert who is kind of neutral and who just doesn't care. Yellow pill NP, I saw that. Jackson, try not to get any more degrees on your way out. So that's the concern. They're just like, yeah, we don't want a clout chaser. We don't want anything like that. So, yeah, and people are saying, but they were fine with Jen McCabe. Jen McCabe is supposedly a direct witness as opposed to an expert witness. So, now I'm just going to say, I don't think, like, Grandma Badass here was looking for clout. I think she's doing all right on all of that. So I think she's just fine. So, yeah.
It seems to sort of.
It wasn't Mr. Giannetti, it was me.
Okay. All right. So the question I asked was answered pretty much by this witness, whether she saw something and decided she wanted to come forward. All right. It's the Commonwealth's motion. What are you asking me to do? Again, I found a violation of Rule 14. There are two concerns here: the competency of the witness's testimony, how much she can testify to, whether she should testify at all.
Okay, so competency of witnesses' testimony, some people were really rubbed the wrong way. She's just identifying, like, hey, these are the issues to address. So,
is it you're asking me, Mr. Lally?
Your Honor, I'm asking that the witness be excluded from testifying at the trial for the violation of Rule 14, specifically, I believe it's Rule 14A6.
Now, I'm just going to say, when when he said, I'm asking that she be excluded, the judge kind of pushes the mic away with sort of a disgusted expression. I, at that point, was like, she's not excluding this witness. She might limit this witness, which ultimately is what she does. But, yeah.
This is a witness, as the court picked up on, that reached out, albeit through an intermediary, with reference to just sort of discovering or coming upon this case in several weeks into the trial. It is concerning, given the fact that the witness represented that she had a subscription to the Globe Online, received word of this, and the first time that she had ever seen it or it had grabbed her attention was in that first week of May, when, as the court is well aware, there's been widespread media coverage, particularly through the Boston Globe, for years at this point.
Now, somebody pointed out that the first week of May, there was actually an article about it being a dog bite, potentially. That might have been what gripped her. I don't know. But the issue isn't that she reads. The issue on this one is he's saying, I don't believe her when she says she didn't see anything about this. That's what he's saying. He's saying that this isn't, like, super credible. And, yeah.
The limitations of the testimony, it's also concerning because the disclosure from counsel indicated, again, as the court had noted, I didn't want to get into too much as far as for purposes of this voir dire, but there was additional material that was indicated in the disclosure that the witness had reviewed, including the UC Davis related to the canine DNA or the lack thereof, as well as, forgive me, the dog bite history of that specific dog, which also I would note for the court includes photographs of what a dog bite from that specific dog looks like. And that specifically apparently was not provided to this witness, who's then opining on, inferably at least, that that dog was the cause of these particular injuries. However, was not shown specifically anything to do with that bite history as far as by way of reports or photographs.
So he's basically saying she didn't see the Chloe bite history specifically, and therefore, how can she say it's this dog as opposed to just a dog? Well, I mean, if it's a dog, it's still pretty bad, but she didn't actually, I didn't see her say it was Chloe specifically. That said, I bet defense counsel is going to show her those pictures and be like, so is this, you know, we'll see.
Juxtaposed or coupled with the immensely late disclosure. I mean, we're talking about at least the 6th week of trial by the time this witness is even mentioned, not on the defendant's witness list, not mentioned at any point in time during the pendency of the case, and then sort of pops up in the middle of May, and to the point that the limited amount of material or information that's provided by counsel as far as disclosure opinion doesn't come until today. So for all those reasons, Your Honor, the Commonwealth is requesting that her testimony in its entirety be excluded from this trial.
Jackson?
Your Honor, exclusion is the highest form of punishment. It's the highest form of sanction that the court has available to it. Just to put a fine point on it, it is a dire remedy. And I know the court has mentioned 2 or 3 times, I'm finding a violation of Rule 14. That sounds as if the court is suggesting or has
this is not a good place to have hurt feelings, Jackson. And I mean, he is pushing back at the court, but it kind of might sound like hurt feelings. No, not pack animals. I've seen groups of both dogs and wolves. So, but yeah, they're group
that
animals.
we did something wrong. We didn't do anything wrong. As the court
I'm not sure what the distinction is
I
between
reached
pack
out
and
to
a
her.
family.
She reached out and said, hey, look, I've got some experience with this.
I asked you that the other day, though, and I was told that you reached out to her through an intermediary. I wasn't told she reached out to you through an intermediary.
I don't know that there's a difference. I mean,
What I was trying to get at is this somebody who read about this case and said, you know, I want to be part of that. That's what I was trying to get at. I think it was pretty clear, Mr. Jackson. Go ahead, continue with your argument.
okay, I'm not misrepresenting things.
I didn't say that.
I take offense at the court's tone. Yes, you did say that. You just said that. You said,
Okay.
I just heard the testimony, and it's not what I said the other day. I know person.
If you're having an argument with the judge about whether or not you are a, whether or not you specifically are a dick, then you're in a bad place, right? So that's not an ideal thing to be. So if I was Jackson, I'd be like, let's get off of this topic and argue for my witness. But he's done well so far. He wins this issue, so I can't criticize too strongly. I just think, I don't like this.
In Los Angeles DA's office, I received a text message from that person saying there's someone who reached out to me who said I might be able to elucidate on this controversy concerning the dog bites. I then reached out to her. So when you asked me who reached out to whom, I reached out to her through an intermediary, my friend in the DA's office back in Los Angeles County.
So maybe it wasn't clear what I was looking for. I think it was clear. Go ahead, continue with your argument on this.
My point is, Rule 14 requires a sanction if, in fact, the attorney has done something wrong. In other words, it connotes the idea that we're doing something by actively hiding evidence or holding back evidence or not providing evidence that you know you're going to use at some point in an effort to take a tactical advantage. And the sanction for that is exclusion. I've never met this woman. First time I laid eyes on her was during the process after she flew out here to engage this voir dire process. She indicated I could potentially provide some information about this controversy concerning dog bites. I then sent her materials. I talked to her. I sent her materials. I found her to be incredibly credible. I found her to be experienced, and I found her to be knowledgeable in this very specific area, which is rare. There's not that many people who have published, doctors who have published in the area of dog bites specifically.
I'm just going to say, finding an expert like this on your issue How do I sort of analogize this? This is like, this is unusual to get an expert who's this good, right? This is an expert who you keep in your, your list, but this is like you go to buy like a gumball out of the gumball machine, and it could be a yellow gumball, could be a blue gumball. What pulls out is just like a diamond the size of a gumball, and you're like, huh, I didn't even know that thing was in the freaking machine. Who put a gumball that big in the machine? Like, who put a diamond that big in the machine? And I guess I'm gonna retire, right? It's this is the kind of expert you really, really want. Yeah, she's a unicorn, although that has some other significant. So yeah, she's just. This is fantastic. This is the kind of witness you really, really want. So yeah.
So I thought it makes sense for me to reach out to her and talk to her, which is exactly what we did. And within a couple of days, literally, you could almost count it by the hours of me receiving her information. We then had a discussion amongst ourselves. Is there somebody that we want to then present on the defense side, on the defense case? And we turned the information over to Mr. Lally. I understand that it was well into the trial, but that's not a fault of ours. And I don't think the sanction of exclusion is necessary or appropriate to punish Ms. Reed from having an experienced witness testify in rebuttal to ultimately what Dr. Scordeballo and the Commonwealth is going to present in their case in chief. That's what she's going to do. She's going to present contrary evidence or an alternative theory of where those injuries came from to a person. Everybody on the Commonwealth side who can elucidate about this has said those injuries come from a tail light, including Mr. Paul yesterday. We have contrary evidence in this.
Now, Mr. Paul was not super impressive, but yeah, they're saying we need this witness. We need this witness to have a fair trial, because in order to have a fair trial, we need somebody to counter this notion that it's a tail light, and this is our witness, right? So he's saying, sure, you've already found that there's a Rule 14 violation. Sure, you're going to impose some sort of penalty, some sort of sanction. But please, 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 please don't blow up our client's case, right? Like, let our client have a case. And that's where he's at.
You should be entitled to present that evidence, even though it came late. It didn't come late by any fault of ours. And I don't believe that the Commonwealth has made out a prejudice that they can't overcome. It's late. Obviously, Mr. Lally is a skilled lawyer. There's nothing to say that he can't or hasn't been able to.
Now, I had some people on Twitter who were just losing their mind about that. They were just losing their mind going, oh, why is he saying Mr. Lally is a skilled lawyer? Well, let me tell you a story. We're going to go to story time. I, at one point, was challenging the government. This was a case that ultimately was reported as Rentschler v. Alberta. Rentschler v. Alberta. Which means, by the way, that I was doing this as a crazy self-rep. Now, I should note, when you're a crazy self-rep, people recommend against it. But I won, so I guess not that crazy. Mildly crazy. But at one point, the other side basically described me as like, Mr. Rentschler is, a very skilled lawyer. He's probably the finest lawyer on firearm law stuff. And it wasn't because he just wanted to, polish my brass, if you get what I'm saying. It was because, I'm being told I'm biggin'. It was because he wanted to show that this was for a mootness application. He wanted to show that I would put up a good fight if I was forced to. So he wasn't saying like, oh, Mr. Rentschler is the best lawyer ever because he really likes me. He was saying it because it was tactically advantageous. That's why Jackson is saying is because it's tactically advantageous. A lawyer who represents himself as a fool for a client. Yeah, unless you win. And the problem I had with so this was an issue of firearms law. And firearms law can be incredibly technical. So the reason why I represented myself is that the next lawyer that I would have trusted to run this one was in Ontario. There's a couple of lawyers in Ontario who would have been willing to, who I would have been like, this is the person to run it. But other than that, I was the guy to make the argument. So I would have recommended me to another lawyer or to another person. And I was like, all right, now I'm just going to note, I lost at trial, but I won on appeal. So I won that case. That's a big, important case. It's Runkle v. Alberta. And it was a case on what constitutes a revocation. So not only did I win that case, by the way, but I won that case. I got costs. I'm not allowed to say exactly how much I got for costs, but I used the money I got from that case to buy a gun, which I then engraved with paid for by the chief firearms officer. Because sometimes you can't just win it. You also got to do your victory lap. So I still got that gun. I would pull it out. I would go grab it and show it to you on stream. But YouTube's got rules. I can't show it to you on the stream. But yeah, that was that case. And yeah, the other side was saying, Runkle is a great lawyer. But it wasn't because they liked me or because they wanted to support me or whatever else. It was just because of that. So, yep. All right. Carrying on here.
Prepare for the cross-examination or for an examination in front of the jury. And I just don't think exclusion is appropriate.
All right. So the second.
I'm going to let this roll, but I'm also going to try to find the picture of my gun while I am doing it. So let's see if we could do that. I think I've got a picture. I'm going to try to pull it up.
Second part of this argument, and I'll start with the Commonwealth first. So in your motion to exclude, you also raise Daubert type concerns. So Mr. Lally, is there portions, if I permit her to testify, are there portions?
Daubert type concerns is basically just, is she suitable to testify to this? Does she know what she's talking about? Is any of the evidence or any of the things that they want to call somebody for, are those outside of her qualifications in any way? And, sometimes it's not just a matter of being a good expert. Because you can have somebody who is the smartest, bestest expert ever and still not able to testify as to what you want them to do. As an example, I am pretty sure I could get an astronaut to testify as to like what being in space is like. But I am pretty sure I couldn't get that same astronaut, even though they're an exceptional person, to testify about firearm operation unless they also have that set of skills. So your expertise has to be relevant and directly connected to what you're trying to prove. So all right, carrying on.
Focus specifically on the part of her opinion where she says, I guess the defense expects her to be able to say she will testify that these injuries are inconsistent with having been struck by a vehicle, road rash, or scratches from broken glass or taillight material.
Seriously, Judge? Like, why are you telling him how to argue this? I didn't like this. I was not impressed by this. I thought this was kind of crap and that she shouldn't be doing it. But, because it's his case to argue. Don't feed him the don't feed that to him. Just let him argue it. I do not appreciate. I do not like that at all. I thought that was not good. So, yeah, I had feelings about that. So, all right. Now, some people might have doubted my story. I'm just going to show you guys a thing for the people who are doubting my tale of firearm law, whatever. So I'm just going to show you a thing here. That is this. So I've blacked out my serial number on it. But you can see it's a Chiappa Rhino with engraving on it that says paid for by the chief firearms officer. So, yeah. I can't show it to you in my hands, but I can show it to you on a picture. So, yeah. That was fun. That was a fun sort of moment in life. All right. Yeah, let's go back to the judge sort of telling Lolly what his case should be.
I think you have an uphill battle on that part, Mr. Jackson. But Commonwealth, what are you saying? If she testifies, what should she be able to testify to? And don't just say nothing. I want some input.
No. If the court were permitted to,
I'm just going to say as well, at this point, when you see the judge say, don't just say nothing, what that means is, Lolly, you've already lost on she's going to get to testify. She's going to get some stuff in. But I am going to limit it, right? Like, this is the signals that you see there.
ask the doctor to testify, Your Honor. What I would submit would be permissible testimony from a legal standpoint. I have some factual questions in regard to that, but from a legal standpoint, I think the court could permit her to testify as to the injuries that she observed, her work in history in that area, observing prior injuries related to animal attacks and whatever consistency she believes that they have with that. I do not think it would be proper to allow this witness to testify or opine anything about the inconsistency with regard to pedestrian injuries. I don't think any proper foundation has been laid for there, whether it be through experiential knowledge in relation to that, or any sort of specialized training or knowledge, or anything to do with that.
So basically, what Lolly is asking for is he's saying, okay, let her test. Like, it's already clear that you're going to let her testify. Okay, cool, but don't let her testify about what it's not. And so this is kind of a big deal, right? Because they want her to testify about what it's not, because what they want her to say is not only is this, yes, this is a dog bite, but they're also wanting her to say it is also definitely not a vehicle strike. And that's ultimately what the judge is going to allow, right? The judge is going to say it's definitely not a vehicle strike. But you know who she did let say was a vehicle strike? Trooper Paul. And I'm just going to say, as experts go, Trooper Paul isn't. Like, if you get all the experts who are qualified to testify in a room, Trooper Paul is going to be sitting there going, where's my invitation? So I don't get this one.
Anything from a forensic pathology or anatomical.
Yeah, they point out defense did not object. I suspect that the reason why defense didn't object was because Trooper Paul humiliates himself, and they're just like, yep, keep doing it.
Pathology perspective, I think, should also be out of bounds and excluded with regard to this witness. She's certainly a very experienced emergency room physician. So anything in relation to that I think it's permissible. But as far as the experience when it comes to motor vehicle crashes or pedestrian crashes, of which the court is well aware, there are a litany of different types of interactions a pedestrian can have with a motor vehicle in a collision sequence. And simply saying, well, there was no injuries to the leg, so it couldn't have been a motor vehicle collision is just plain wrong, and not backed up by science or anything else.
I don't know that you actually know the science, Lolly, but okay.
That this witness can testify to from the very limited experience she has in that realm. So if the witness were able or permitted by the court to testify, I would submit that her testimony should be relegated to simply what, if any, opinions, her experience, obviously, and then what, if any.
Oh, my God. Lolly, you're not questioning a witness. You don't need to what, if any. Like, oh, man, I did not like that at all. The what, if any. Like, just let it go, man. Let it go. Frozen that shit.
Any opinions she draws with regard to the causation of the injuries on the right arm, as it pertains to consistency there. But I venture to guess that it's likely that those are probably also going to be, in her opinion, consistent with many other causes beyond that, if she's being reasonable.
All right, Mr. Jackson.
I'll submit, Your Honor. I have no issue with. I just said I'll submit. I'm not submitting. I have no issue with limiting her testimony to the animal attack issue, the dog.
The reason why he has no issue with this, by the way, is because he already knows how she's ruling, right? And what he's basically doing here, this is a tactical move on his part. He already knows what she's going to do. And so what he is doing as his response is to say, I'm going to give you what you want, Judge. You can have what you want. And the reason why he's doing that is to keep the judge from going further than that. So he definitely wants the dog bite thing. So, I saw some people who were like, oh my God, why is he giving this away? I'm like, he's giving it away because it's, actually sensible. So, I got nothing wrong with this.
That issue. I didn't, as the court noted, I didn't spend any time. I think I may have asked one question that's consistent with the motor vehicle incident. I have no problem if the court wants to limit her testimony to the dog bite aspect and not the motor vehicle aspect. I wasn't planning on going into that aspect anyway. I've got another pathologist who's going to do exactly that.
But you did go through it with her, and it's on your disclosure.
It is, but I have no problem editing.
So why is it on the disclosure, or where the Commonwealth turned over, that she viewed all reports associated with Chloe's bite history and the UC Davis DNA testing? Why is that in there?
Because we set that in a Dropbox. We set everything in a Dropbox, and I assumed that she reviewed it. She must not have seen it or opened it or reviewed it. I didn't know. But that's what was sent to her. Everything that's in the disclosure is what was sent to her.
Right. If she's permitted to testify, you led her through quite a bit today. You won't be able to. I mean, she...
He knows, right? The reason why he was leading the witness is because it's on voir dire, and she's saying basically you can't lead your witness on voir dire. Okay, he knows. He knows.
Struggled with to what degree of certainty she held an opinion. She struggled to what she viewed.
What she's saying about she struggled with what certainty. She just didn't know the right words, right? She didn't know the specific legal test there. And that's a thing that maybe could have done more prep, but I thought she did great. So
didn't write a report. I have to consider all of these things too, as the gatekeeper, as to whether she can actually assist the jury. So I'm not deciding this right here. Mr. Lally, if I do permit her to testify, I will give you time to absorb this testimony and to find an expert in rebuttal for this. How long might something like that take?
Not terribly long, Your Honor. As far as
not terribly long, because they've got the resources of the government, and the resources of the government are basically infinite. So, yeah.
I can't give an exact time frame on that. As far as a rebuttal witness, I'd say a week at the most.
A week from today?
Yes.
Why don't you start looking at least? All right. Well, I decide I won't know until Thursday.
Sure.
All right.
By the way, when when the judge says, I won't know until Thursday, but you should start looking now for a rebuttal witness, what it means is I'm letting this witness in, but I'm going to give a full decision later, right? When it's like, that was kind of obvious. That was a bit of a giveaway, right? So, yeah, that was a bit of a giveaway there.
All right.
And yeah, why don't they just use Trooper Paul? Epic 7000 says, Runkle, if the resources of the government are infinite, why don't they have all the best lawyers and always win cases? They're infinite when they want them to be, but they don't always want them to be. And it's complicated, I guess, is where we're on that. Okay, so we're going to move on from that on to our next witness. Accident reconstructionist from ARCA.
Thank you, Your Honor. Sir, could you please state your name and spell your last name for the record?
Daniel Wolfe, last name spelled Wolfe.
So what do you do for a living?
I am the director of accident reconstruction at.
Now, guys, I meant to be more prepared for this. So I meant to have a clip for right now, but I don't have the clip. So I need you to imagine the clip. And the clip is from Pulp Fiction. And the clip is Jules and I'm forgetting Vincent calling their boss going, we are in some trouble right now. We're and he's like, relax. And they're like, don't tell us to relax. And it's like, relax. I'm sending the wolf. And they're like, oh, you're sending the wolf? We're good. Right? That's the clip I wanted to show here. So I don't have it, but imagine that clip right here. Just insert that here. Also, I avoid a copyright strike with it, but yeah.
Company known as ARCA, ARCCA.
And tell us a little bit about ARCA. If you could explain to the court what ARCA is and what its primary mission is.
So ARCA is a forensic consulting engineering company. We have a variety of disciplines that include biomechanics, failure analysis, human factors, premise liability, crashworthiness, and accident reconstruction.
Okay, that's a lot of things. Let's put that down to 1x speed, and I'm going to try to explain the things because so many things they do.
CA.
And tell us a little bit about ARCA. If you could explain to the court what ARCA is and what its primary mission is.
So ARCA is a forensic consulting engineering company. We have a
Okay, so forensic is basically dealing with courts. So a forensic psychologist is a psychologist who does stuff with regards to court processes. Forensic psychologists study jury psychology. They study eyewitness stuff, all of that stuff. So a forensic engineer basically is going to look at what happened from an engineering perspective. So, okay, let's keep going here.
Variety of disciplines that include biomechanics.
Biomechanics is basically you are a body. It's got all sorts of moving parts. How do those parts move in ways that cause them, injury or whatever else?
Failure analysis, human.
So failure analysis, something broke. What happened? How did it fail? And especially when it's something broke and somebody got killed. Something broke. A crane failed and, caused a whole bunch of damage and a guy died. Cool.
Factors, premise liability, crashworthiness, and accident reconstruction.
Okay, human factors is basically so one of the main causes of safety incidents at like a factory is people are stupid. And so as an example of this is that you might have a safety feature. Let's say you've got like a big press that stamps metal down and into a shape, right? And this big press to stamp metal down, well, if your head is in the way or if your hands are in the way, that thing is just going to squish whatever's in the way, right? And so what they might do to prevent that is they might actually have two buttons that you have to press. I actually have this with my meat slicer. I have a meat slicer, and it's got this button that you've got to pinch. And that is so that your one hand has to be out of the way of the blades, right? You can't forget where your other hand is because you've got to hold down the button and pinch it to make it work. So, so let's say you've got to hit two buttons on the side of this machine to make the press come down. And the reason why they do that is to keep your hands from the machine, right? So what do people do? Well, they get some duct tape and they hold the button down because the button turns out to be a pain in the butt. And then somebody loses an arm, and then this guy comes in and he's like, so the way this accident happened is dumbass here who lost his arm did it because he bypassed the machines. So this guy does all the things, right?
You said that you were the current director of accident reconstruction, correct?
That is correct.
Is that a specialty of ARCA specifically?
Yes, sir.
And what sort of contracts does ARCA routinely engage in?
We typically work for law firms, insurance carriers.
So insurance carriers, why would insurance carriers care about this? Well, because often insurance does not want to pay out. And insurance gets to not pay out a lot of the time if you have done the stupid thing, right? If you've done the dumb thing, then insurance may be able to say, yeah, we don't have to pay for your injuries because you did the stupid thing. They also sometimes want to know things like, hey, there have been 2 accidents at this factory where people have lost their arms. And it's really expensive when people lose their arms because now you've got to, you got to pay for them to, all of that stuff. The 357 Chapel Rhino. So people losing arms is super expensive, and it also shuts the factory down and all of that. So the insurance carrier might be like, hey, we need this guy to tell us what happened and how to make it not happen anymore. So cool.
What about other clientele? For instance, maybe it's an insurance carrier or a law firm, but what about the ultimate client, the military, Department of Defense? Have you contracted with other entities or agencies, sporting agencies?
Certainly, yes. We've done research for the military. We do player safety for the NHL. So yes, we are involved in a number of research projects as well.
And
okay, why does the military care about this? Well, because the military involves a lot of, you don't want to have people get injured, right? And so the military is going to try to determine, like, how can we avoid that? Also, military's got big budgets, so yep.
in terms of ARCA and its commissions and consultation, is it known both nationally and internationally? Is it recognized as a leader in the area of accident reconstruction?
Yes.
Down,
As the director of accident reconstruction, do you specialize in not only accident reconstruction, but human
Safety,
factors
Daddy.
as well?
Yes, sir.
Can you give me a synopsis of the professional discipline of accident reconstruction? What is accident reconstruction?
Crash Daddy.
Well, I think that's a very broad topic. I look at the cases that come across my desk. I've been involved with pedestrian impacts, and that can be pedestrians seeing the side of vehicles, fronts, backs, getting run over by vehicles, being struck by a vehicle, then projected into another vehicle. I've dealt with your simple fender bender collisions. I've dealt with collisions that involve 60-car pileups on a highway. So again, accident reconstruction in terms of the scope for a case, it can really vary case to case depending on the facts and circumstances of that case.
And when you say dealt with, are you talking about literally going into, from an engineering and a scientific standpoint, trying to reconstruct what happened, what the causal effects were of that accident, and what the results were, the resultant damage or injuries were?
Absolutely.
What about human factors? What does that discipline entail? What is human factors?
Well, to give you an example of that, so I do a lot of nighttime visibility work where, for instance, let's say a pedestrian's coming onto the roadway at night. Maybe it's not a lit roadway and you're relying on your vehicle headlights to illuminate that pedestrian. So it's determining when would a driver recognize that individual on the roadway based upon the headlights, if there is any artificial lighting, their clothing. And then we look at how do drivers respond based upon that scenario that they're presented with. So we know that response times are different depending on the hazard that's presented to them. So if it's a pedestrian.
Okay, so basically what happens is sometimes pedestrians get run over, and that sucks. But sometimes you got to figure out, like, whose fault is it? Because sometimes it's the pedestrian's fault that they got ran over, which I know might sound pretty crappy, but it is totally true that sometimes pedestrians are at fault. And so basically he's saying, like, you step out between two cars at night in front of another car. Could the driver have seen you? Is that, because if the driver couldn't possibly have seen you, then it's not their fault, right? So that can be a big deal.
Coming to the roadway, it's a vehicle stopping in front of you. So that's the application of human factors.
And that might include everything from passenger vehicles, commercial vehicles, bicycle issues, motorcycle issues, things of that nature.
Yes, sir.
Okay. What education, training, and background qualifies you to perform the duties that you just described as director of accident reconstruction at ARCA?
In terms of my educational background, I received a Bachelor of Science in Engineering from James Madison University back in 2012, along with a minor in mathematics. Some of my coursework while at James Madison included courses in physics, statics, dynamics, kinematics, material science, and your typical engineering sciences.
But sir, did you get 120 hours in? Did you manage to get 120 hours in? Because if you don't have your 120 hours, then we're not interested. I feel like this guy's got a little bit more expertise. So we're going to skip past a lot of it because his expertise is going to take forever. So we're going to skip like 30 minutes.
Would be Dr. Andrew Rentschler.
Obviously, Dr. Wolf, in coming to your opinions and conclusions concerning the damage to the vehicle, you had to consider the damage to the human being, correct, John O'Keefe?
Correct.
And as the team leader, in terms...
Now, I'm just going to note, they had no ability to prep for this because this is the first time they're talking to this witness. So there is no prepared for this witness. There is no any of that. It's just, here's a guy they're just going to talk to. So...
of Dr. Rentschler coming to his conclusions and opinions concerning the damage to the human being, he also had to consider the damage to the vehicle and the interplay of the two, correct?
Correct. We work together.
I was just going to say, is that how you two and Mr. Klein work together to come to the opinions and conclusions that are cited in your multi-page report?
Yes, sir.
That's all I have, Your Honor.
Okay. Mr. Lally?
Thank you, Your Honor.
All right, let's see cross.
Good morning, sir.
Good morning.
Now, you went through a list of about 14 things that are contained within your report that your firm or your agency was provided with that you reviewed, correct?
That is correct.
Did you specifically review all 14 of those things, or was that done as sort of a team?
Yes, I looked through all of the documents.
Do you personally look at all 14 of those items that are listed within the report?
Yes, sir.
And you indicate that it was your opinions or what you did in this case, that was you were asked to answer specific questions, correct?
Yes.
It wasn't like you were just tasked with.
Now, one thing you won't hear, by the way, from any of this, you won't hear at all, is them mentioning who hired them. And the reason why is because they've been told not to mention the FBI. The jury doesn't get to hear the words FBI. So, yes, I did skip the MRAP and the NFL pieces he designed because there's so much stuff and we want to get through it tonight. But yes, he designed stuff for the NFL. He designed sort of a special spring-loaded glass thing to prevent injuries. He helped design armored vehicles to help protect people from mine explosions. So yeah, they don't want to mention FBI to the jury at all. So, oh yeah, NHL.
Here's some facts, go do or take a look at a crash reconstruction or create a crash reconstruction. You were asked very specific questions and you tried to answer them the best you could, correct?
I don't know that there were specific questions. I think ultimately it was an open-ended question.
But related to you testified as to two specific areas that your firm or your agency looked at, right?
Those are the disciplines that the report covers, yes.
You had testified about some other areas of expertise as far as human factors, visibility, luminescence, things like that. You didn't do any of those things here, correct?
Wasn't part of my scope in this case.
And the scope in your case, you indicate that it was based on the evidence, correct?
That is correct.
Now, to be fair, that's based on the evidence that you were provided, correct?
Correct.
So what did Mr. Klein do?
So as a part of the engagement with the entity that ultimately retained us in this, due to the confidentiality of it, only those who had access to the material to the file were allowed to review it and discuss it. And essentially, Scott Klein.
So this file was probably noted as like one of those files where if you search that file up and you're not on the list, that you get fired.
Served as kind of another reconstruction expert to essentially bounce ideas off of and help with the review.
So for lack of a better term, sort of provided, let's say, sort of technical review of your work and Dr. Rentschler's work, is that correct?
I would say assist us with the analysis, yes.
Now, obviously, your firm and your agency issued a report in relation to what you did, correct?
That's correct.
And you've obviously had a time to review that report as far as what's contained in there factually, as well as conclusions and opinions, things of that nature.
Yes.
So is it your testimony that anything that has to do with anything factually, conclusions, opinions, or otherwise, in relation to the motor vehicle damage, those are your opinions, those are your conclusions, correct?
I would say that's fair, yes.
And again, based on the evidence that you were provided, correct?
Correct.
And so the facts or evidence or conclusions or opinions related to injuries to Mr. O'Keefe, that was Dr. or Mr. Rentschler's area, is that fair to say?
Dr. Rentschler, yes.
And again, that was based on the evidence or whatever he was providing, correct?
Correct.
Which would be the same materials that you had testified that you had reviewed, correct?
Correct.
I have nothing.
Anything further, Mr. Jackson? All right, so Dr.
As cross-examination goes, that was a pretty gentle cross-examination. I'm pretty sure Lolly saw this guy coming and was like, I am just not going to be able to, I'm not going to be able to keep this guy out. Like, just full stop. All right, so now we move on to Dr. Rentschler.
Thank you, Your Honor. Sir, could you please state your name and spell your last name for the record?
Certainly, Dr. Andrew John Rentschler, Rentschler.
Sir, what do you do for a living?
I am a biomechanical engineer and accident reconstructionist.
In what area of the country do you live in?
I live in Pittsburgh, Pennsylvania.
What is your title currently at your company?
I am a vice president and director of biomechanics for the Midwest Division.
And what is the name of that company?
It's called ARCA LLC.
And what is the main mission of ARCA? What does ARCA do?
So ARCA is a engineering consulting company, and we have several different types of engineers, biomechanical engineers such as myself, accident reconstructionists, mechanical engineers. We look at crash worthiness, safety of vehicles, and other types of events. So we really do all types of work. We do litigation type work, as well as research and development for government and private entities as well.
Let me have just a moment, Your Honor.
Yes.
Now, I didn't know who ARCA was before this, but now I'm like, okay, these are the guys
Can you give me
call.
a brief synopsis of the professional discipline of injury causation biomechanics? What is that?
So injury causation biomechanics is really applying traditional engineering principles to the human body. So as a biomechanical engineer, I look at the response of the body to accelerations and forces and determine how an injury occurs. You know, an injury to the human body is just an engineering problem. For instance, a mechanical engineer might look at a piece of steel and you know the size of the steel and the shape of it. And if you apply a force in a certain direction, that steel will bend and eventually break. Well, we do the same thing, but we look at the human body. How much force do you have to apply, and how does that force have to be applied in what direction or manner to get a specific injury, whether it's a
So, this is the guy who knows exactly how to break a bone. I feel like it's a good thing that these kinds of people are like on the side of good, because otherwise they would be really, really terrifying. Can you just imagine this guy who when he needs to be intimidated because he's like, hey, I know precisely how much force it takes to break a bone. So yeah, it's just gonna say, I'm just gonna say that would be creepy.
skull fracture, an intervertebral disc injury, a concussion. So we look at the response of the human body to different forces and accelerations in different types of settings. And ultimately, our hope is to help mitigate or prevent injuries, whether it's in a motor vehicle accident, sports setting, industrial setting, auto pedestrian impact, try and make products and environments safer for individuals.
And that's different from what medical doctors do, correct?
It is, yes, sir.
A little boy walks into an ER with a broken arm, the medical doctor wants to reset the arm and fix the arm, correct?
That's right, yes.
What does a biomechanical engineer want to learn about the broken arm?
We want to learn how that break or that fracture occurs. I always say that we kind of approach injuries from two different directions. You have an injury occur. After it occurs, moving forward, that's when the medical doctors get involved. They diagnose the injury, determine the best way to treat it, what's the prognosis. As a biomechanical engineer, I kind of take the reverse direction. We look at, here's the injury, here's what's diagnosed. Well, how did that injury occur? You know, how much force do you have to apply to cause that fracture? How did the bone have to be loaded? How did it bend to actually cause a specific type of fracture? So we really kind of...
He's like, we look at a broken arm. Like when a child comes in with a broken arm, we go, how could I do that again if I had to? That's kind of what he's saying, although not really what he's saying, but also kind of really what he's saying. So yeah, how could I break that bone again exactly like this?
Approach the injury from two different directions.
Understood. And given that scientific approach, oftentimes you come to conclusions and opinions, scientific conclusions and opinions about the causation of an injury, correct?
Absolutely. Yeah. I mean, ultimately, that's what biomechanical engineering is how does an injury occur? Why did it occur? And what type of setting did the injury actually occur? What type of loading and what type of kinematics do you need to have this injury actually occur?
Can you tell the court a brief synopsis on the discipline of human factors? What part does that play in what you do for a living?
Well, human factors is a large part of it as well. I mean, from a biomechanical standpoint, we look at the body, we have to know anatomy, we have to know the makeup of the body. And then human factors plays a part of it as well as how individuals respond or what their response is to different types of environments or reactions. It really all plays into looking at a specific event. How did someone react? How did their body move? How was the body loaded? There's all different types of factors that you have to apply. The human factors, kinematics, kinetics, biomechanical, musculoskeletal interactions. It's all these different factors that are really involved in performing an analysis to ultimately look at injury causation.
Doctor, as the director of biomechanics and human factors at ARCA, what education, training, and background qualifies you to perform those duties?
Well, I got my Bachelor's of Science in Mechanical Engineering with a minor in Biomedical Engineering from Carnegie Mellon University in 1995. I then went on to get my master's.
Oh, is that all?
in Bioengineering and Biomechanics from the University of Pittsburgh in 2002. And then I got my PhD or my doctorate in Bioengineering and Biomechanics from the University of Pittsburgh in 2004.
Okay, so this guy's a bit lazy compared to grandma there, but I feel like he's doing okay.
Can you give us a brief work history up to and before ARCA?
Sure. So I got my PhD in 2004, and then since then I've worked in the consulting field for biomechanics. I've worked for a company out in Davis, California for a while called Biomechanical Engineering Accident Reconstruction. I then joined another engineering company in Jacksonville, Florida for about 3 years called Chesapeake Engineering and Design. And I have now been with ARCA for approximately 16 and a half years.
And in those positions and in your position currently as a director at ARCA, do you specialize in research and analysis attendant to evaluating and studying the relationships between crash injuries, crash forces, human kinematics, and human tolerances?
I do. I mean, that's really what I do on a daily basis, whether it be in litigation type cases or the research and development we do for different companies or entities, or even internal research that we perform at ARCA.
Doctor, what professional associations and accreditations do you have?
I'm a member of the American Society for Mechanical Engineers, as well as the Society for Automotive Engineering. Yeah, with respect to biomechanical engineering, there's no actual professional licensure for biomechanical engineering. So a PhD or a doctorate's the highest degree you can have in that field.
Are you also a reviewer for archives, physics?
Which he just happens to have. It's like, this is the highest degree in that field. And, oh, right, I totally do have that. So, yep. Yeah.
Physical medicine and rehabilitation and biomechanical engineering online?
I am, yes. Well, usually if you publish articles in a journal, usually that journal comes back to you and asks you to be a reviewer. So I certainly do that type of work as well.
I'd like to ask you a couple of questions about your ongoing education, your professional education after your PhD. Have you continued your education in areas of biomechanics and high impact injuries from the NTSB?
I have. I've taken classes through the NTSB and SAE, the IPTM, Police Technology Management Training Center. There's several different entities I've taken biomechanical and accident reconstruction courses through.
So the alphabet soup, if you will.
Oh man, these guys are so bad for my imposter syndrome, because I'm just like, oh, I have accomplished none of this. I found out lots of the MSP shaved heads. They took part in the annual Buzz Off to raise money for kids with cancer. The official event was in May. However, some groups did smaller events later. You know what? Good for them. I will not give them any more crap about the shaved head look, because good for them. All right, let's jump into a little bit of what he has to say and so forth.
It has been.
And our troops utilizing that new seat design, that safety seat design.
Whoop, I got my timestamp a little wrong there.
What about additional studies and research in this general area?
I have, yes, sir.
Can you describe that for us briefly?
Certainly. Well, just at ARCA, I've worked with the United States military. We worked on the design of the MRAC vehicles, the mine-resistant ambush-protected vehicles over in Iraq and Afghanistan.
That's a troop carrier, correct?
That's correct, yes. And the issue there is they go over the IED, the improvised explosive device, and it blows the vehicle up off the ground. So you're getting very large forces and accelerations through the vehicle, through the seat, into the soldier's spines. So we're seeing very traumatic and severe spinal and head injuries. So at ARCA, we work on what we call an energy-absorbing seat design. So when the vehicle gets blown off the ground, that seat is designed to absorb the force and the energy to protect the soldier's spine and their head.
Did you take part in the design of that seat?
I did, yes, sir.
Has that been employed by the Department of Defense?
Yes, it has been.
And our troops utilizing that new seat design, that safety seat design in that troop carrier to this day?
As far as I know, from what they'll tell us, yes, sir.
Understood.
Okay, so this guy designed a chair to prevent U.S. soldiers from getting paralyzed or killed by mine explosions. How do you think the jury's going to like this guy? How do you think the jury is going to feel about this guy? Because, I feel like the jury's going to like him plenty. I feel like the jury is going to be sitting there going, oh, this guy is a freaking hero. Because, I mean, I get that he probably hasn't served overseas and whatever else, but I guarantee you that there are some soldiers who are alive or who are walking today because this MF exists. This guy is a badass. This guy is awesome. And I feel like the jury is going to look at this guy and be like, oh, let's compare that to Trooper Paul, who has heard of physics, right? So, yeah. He's an awesome dude. All right, so now we're gonna see Lolly try to take a stab at the world's best guy. Let's see how this goes.
Good guys.
Just a few questions for you, sir. Good afternoon.
Good afternoon, sir.
Now, with relation to your work in this instance, in this case, were there any limitations as far as confidentiality or anything that were put on you or any of your team?
What do you mean by
Thank you,
confidentiality?
As far as who, what, where, and how you could discuss what you did?
Well, yeah, I mean, certainly we just discussed with who we were retained by in this case. I don't believe I discussed the case with anybody else except for my cohorts who were also involved in the case.
And so my question, sir, more is geared towards, at some point you were made aware that your report, your findings were made available to both the prosecution and the defense in this case, correct?
I was made aware of that, yes, sir.
And when you were made aware of that, was there any limitations on given to you as far as who you could discuss your report, your findings, or anything with?
Yeah, basically given the direction or the request that I don't actually discuss the substance of my opinions or my report with anybody aside from who we were originally retained to work for.
Now, may I approach, Your Honor?
Yes.
Sir, I am going to show you the first couple pages of your report, specifically right down the bottom. There's a list of items 1 through 14. I asked you to give those a couple of minutes.
Okay.
Now, is the totality of information that you and your firm were provided with in reference to what you did in this case?
I believe it was, yes, sir.
I'm going to skip ahead on this because, quite frankly, I think that Lolly's cross-examination here is going to be a little boring. I'm going to just explain what his cross is about. His cross-examination here is just about trying to nail these witnesses down to their testimony. Basically, your report is your report. You didn't look at anything that we don't know about. Everything is as is expected. He doesn't try to take a swing at these guys' credentials. He doesn't try to take a swing at anything else. He just really basically is like, let's try to pin these guys to their own statements. So with that in mind, we're going to move on, and we are going to we're going to go on and look at day 28. And I know day 28's got some interesting stuff to it. So I want to get to day 28 because kind of important. All right. I'm going to embiggen. Oh, people want the swoop. Swoop. All right.
Discovery or voir dire hearing in
Okay.
response
So we're going to start off with the judge ruling on the voir dire.
to the Commonwealth's renewed motion for reciprocal discovery and motion to exclude defendant's expert, Dr. Marie Russell. So the Commonwealth was alleging violations of Rule 14's reciprocal discovery requirement, and the Commonwealth asked for exclusion of Dr. Russell. I did find and do find that there was a violation of the reciprocal discovery obligations of the defendants. I was looking for a remedy. You called it a sanction, Mr. Jackson, but I called it a remedy. And I did tell counsel, as you know, at sidebar a couple of times, at least last week, that I did not want to exclude the testimony if I did not have to. So we had the voir dire, and I'm satisfied that the voir dire provided the Commonwealth the information that the defense should have provided the Commonwealth.
This is kind of a critical thing. She's saying, I'm not knocking your evidence out. I'm going to let you argue the stuff. So
I am going to allow Dr. Russell to testify, but her testimony is very limited, and I think you even sort of acknowledged it the other day, Mr. Jackson. So she'll
he
be
did.
allowed only to opine whether or not the marks on John O'Keefe's arm were the result of an animal attack. I find that she is a medical doctor. She's an experienced ER doctor, albeit, several years ago since she's worked in that capacity, but that she does have specialized knowledge in that field that may assist the jury in this regard. But she can't testify as an expert on police activity. There'll be none of that. And she will not be able to testify as to what the injuries are inconsistent with. She cannot testify that they're inconsistent with having been struck by a vehicle, road rash, scratches from broken glass or taillight matter, or anything else. So that's beyond the scope of which she can testify. The second part of
So that is a win for a bit of both sides. And what I mean by that is that ultimately she can't testify about about what it's inconsistent with. So what they can't say is this couldn't have been caused by a car, right? So this is a limitation on the field of things. So, yeah.
Commonwealth's motion, Commonwealth argued that they were not provided reciprocal discovery regarding the biomechanical engineers and others, but specifically ARCCA, Dr. Wolf, and Dr. Rentschler. And I do find, though I understand why the defense didn't respond, but it is a violation of Rule 14. So we had this voir dire. The Commonwealth was looking to see what each person did, their independent opinion, what their testimony would be, and whether they were qualified to render the opinions that they qualified. So from what I heard the other day, Dr. Wolf can testify to what his involvement. Dr. Rentschler, though, I have some concerns.
Okay, so this is the second doctor. Dr. Wolf is good. Okay, Dr. Wolf's in. What's the next one?
clear to me that in Massachusetts, biomechanical engineers are not qualified to testify as to medical causation of an injury. Only an MD can do that. So I'm going to reserve ruling on the rest of his testimony. There are certain things he can testify, and I'll hear you again before he testifies next week. Let's just proceed with the trial today. So,
Yes, Your Honor. Thank you.
okay, so those are.
Okay, so the problem is, and I don't know if this is statutory or case law, but basically what she's saying is that the only people in Massachusetts who are allowed to give opinions on causation of a death or an injury are MDs. I don't know that that's true because that seems really weird, right? That seems strange. But she's saying, I'm letting 2 out of the 3 witnesses in. The third one, we're going to have more argument. Now, I'm going to say I tried to find that. I tried to look this up in the limited time I had today. And when I say in the limited time today, I was literally watching this, and in another window, I was trying to do case research on that. I couldn't find it. So... And the other thing is that if that is the case, then why the fuck was Trooper Paul allowed to testify? So if I'm the defense, I'm going to be like, listen, Trooper Paul said that this injury was caused by this, this tail light. Now you're saying this guy can't? This guy's way more qualified.
My rulings, are they clear, Mr. Jackson?
Yes, sir.
Are they clear, Mr. Lally?
Yes, Your Honor.
Okay. All right. So are they ready to come in?
Yes.
Thank you. We'll just go right into it.
All
Thank
eyes,
you.
jurors entering.
All right, we're going to skip past jurors entering.
Defendant's phone and Mr. O'Keefe's phone, correct?
Yes, sir.
And Your Honor, may I approach?
Yes.
All right, so this is the same guy from last time, still on the stand.
I'm showing you a document, asking to review that with open finish.
Okay.
You recognize that, sir?
Yes, it's
What do you recognize that to be?
Karen Reed's phone call logs.
And that's specifically from January 28th and January 29th, is that correct?
Yes, it starts the 28th at 12:33 to, I'm sorry, the 29th at 12:33 to 3:19 p.m. on the 29th.
And just for ease of reference, does it sort of go in descending order as far as the earlier calls are on the last page and then the more recent calls are on the first page?
Yes, that's correct.
May I approach, Your Honor?
Yes.
I'm about to introduce him as an exhibit. May we approach, please?
All right, so what's going on here? They're now having a sidebar. We hate sidebars because we don't get to see them.
Showing you another document, sir. Do you recognize that?
Yes,
What do you recognize that to be?
this is Karen Reed and Kerry Roberts' call log.
And that's an extraction report that you created from the defendant's phone, is that correct? Yes, sir.
Yes. Sorry, yes.
May I approach again, Your Honor?
Yes.
I'm off the seat.
I'm just also going to note my attention deficit is playing a little bit haywire with me. And I've got a bit of I got to make it back into the leather shop, and I'm going to explain why. So, a friend of mine, a younger, he's a younger guy. He is becoming a full lawyer, and he's going to have his bar call, which is when he becomes a full lawyer. That bar call is coming at the end of the end of July. So, I want to make him a gift, as a congratulations on becoming a lawyer. But can I turn on the closed captions are unavailable. So I got to get on that because I'm running out of time. So I got to figure that out.
Introducing the bid as an extra.
Okay.
No objection.
6:34.
May I approach again, Your Honor?
Yes.
Showing you another document, sir, to recognize that.
Yes.
What do you recognize that to be?
This is the chats from John O'Keefe and Chris Albert.
And again, that's an extraction report that you created from Mr. O'Keefe's phone. Is that correct?
Yes, it is.
May I approach again, Your Honor?
Yes.
I'm going to introduce him as an exhibit. No objection.
I see people saying embiggened. I don't know why it is embiggened. By the way, this pause moment, he is scratching his face. He is not he's not picking his nose.
Mr. Lally, you really do need to keep this up. It's 6:35.
And may I approach? Oh, I'm sorry. My apologies. May I approach again, Your Honor?
Yes.
Showing you another document, sir. I asked you to look at that. Look up when you're finished.
Yeah, I think it was fairly obvious. I just didn't want to do the guy too dirty on the pause.
Yes.
Do you recognize that, sir?
Yes, this is Karen reads the full chat report of everyone from the 29th on.
May I approach, Your Honor?
Yes.
I'm going to introduce him as an exhibit. We have no objection.
6:36.
Sometimes, but you do have to ask. You do have to ask the judge. So, and the judge could say no. Like, may I approach to do a demonstrative? Judge could say nope.
I'm sorry. May I have the last one? May I approach the witness, Your Honor?
Yes.
So returning to you what's now been marked as Exhibit 636. Your Honor, with the court's permission,
Good gifts for a lawyer, a briefcase, a rolling bag, notebook cover. Yeah. All right. So let's jump over to the chats.
these conversations on page 28 through 29 of this exhibit occur in the early morning hours of January 29th, correct?
Yes, that's correct.
And if you could, sir, again, please read as far as who's speaking, what they're saying, and what date and time these are being sent.
Yes. So Karen reads to John O'Keefe at 12:55 a.m. on the 29th. I'm going home. Followed by, see you later. At 1:02 a.m., she texts John again saying, your kids are cucking alone. And at 1:04 a.m., she says, I'm back in Mansfield. The kids are home alone.
I am pretty sure she didn't mean to say cucking. Now, these seem like weird things to send to somebody if you think that they are dead. Or if you're concerned that they are dead, right? Yeah. Yeah. All right. Let us go and jump ahead a little bit here. There's a moment that I'm going to try to capture.
Second.
And as far as any indication on those calls, as far as whether they're answered, they're missed, they're rejected, or what are they listed as?
There's nothing. Also, 133 is the same call. And that one says missed. And it's at the same timestamp of 12:36 and 9 seconds.
So the same call around the same time frame shows up in Mr. O'Keefe's report as missed and shows up in the defendant's report as answered, correct?
That is correct.
And that is around the time that the defendant is calling the victim repeatedly and leaving voicemails on Mr. O'Keefe's phone.
Yes, that's correct.
May I approach just to retrieve, Your Honor?
Yes.
Yes.
Now, Trooper Garino, you conducted an analysis of both the defendant's phone and Mr. O'Keefe's phone, correct?
That's correct.
And from your analysis of that phone, were you able to determine approximately how many calls occurred from the defendant's phone to Mr. O'Keefe's phone from the time period shortly after 12:30 a.m. To the time period shortly after 6 a.m.?
There was over 50. I think it was 53 or 55.
And any of those calls from your review of those records indicate any sort of conversation as far as duration, as far as being labeled as answered, anything to that effect?
That Mr. O'Keefe actually picked up the phone and spoke to Ms. Reed?
Yes.
No.
Now, with regards to those phone calls.
Now, I missed it if it happened. Somebody said it was at this timestamp. There it is. There it is. All right, so let's go back and listen to this. So now I'm just gonna say I'm not sure because it could be shoot me. That's what everyone on Twitter is saying. You know what I think it actually is? I don't think it's shoot me. I think he said, excuse me. Excuse me. I think that was excuse me. I don't think that was kill me. I think it was excuse me. You know, excuse me, but sort of shrunk down, excuse me. I think that's what that was. I think it was because he coughed and he just said, excuse me. So I don't think he'd make that same mistake twice. So I think it was just excuse me. That's my take on that one. I'm sticking to it. It just is what it is. All right. Yeah, let's move on here. There's some more stuff I wanted to cover here, but all right. First thing is at about an hour in. Actually, no, we want to get to his voicemails first.
Now, Trooper Garino, you conducted an analysis of both the defendant's phone and Mr. O'Keefe's phone, correct?
That's correct.
And from your analysis of that phone, were you able to determine approximately how many calls occurred from the defendant's phone to Mr. O'Keefe's phone from the time?
Oh, guys, the kill me was last time. We already covered the kill me. He definitely said kill me. Like that was 100%. But I think this one wasn't a shoot me. Yeah, he definitely said kill me. We covered that in a previous recap. But yeah. This I don't think this was a repeat of that.
Period shortly after 12:30 a.m. To the time period shortly after 6 a.m.
There was over 50. I think it was 53 or 55.
And any of those calls from your review of those records indicate any sort of conversation as far as duration, as far as being labeled as answered, anything to that effect?
That Mr. O'Keefe actually picked up the phone and spoke to Ms. Reed?
Yeah.
I'm not going to do fight Coke or angry Coke today. That was just bad.
No.
Now, with regards to those phone calls from the defendant to Mr. O'Keefe, what, if anything, did you find from Mr. O'Keefe's phone in relation to voicemails left by the defendant?
There were should be 8 voicemails on Mr. O'Keefe's phone from the 29th till the phone was discovered. All from Ms. Reed, no one else.
Okay, this is probably a good point for the spice swoop because all right, so we're 2 hours in. We are a little more free to be spicy and yeah.
May I approach, John?
Yes.
So we're going to hear the voicemails.
Going you with this, sir. You recognize that?
Yes.
What do you recognize that to be?
It's the John O'Keefe voicemails from Karen Reed on his phone.
From that period that we were just speaking about on January 29th?
Yes, that's correct.
May I approach, John?
Yes.
I'm on the station introducing the minutes of the next exhibit.
Now, I mean, he's like, yeah, I recognize this CD or this DVD. I'm like, yeah, but somebody could have like made a similar DVD. It's funny when they do that with like USB keys or like USB drives because, yeah.
No objection.
Now, sir, from your review of the defendant's phone, before we get to those, from your review of the defendant's phone, what, if anything, were you able to observe or ascertain that the defendant's phone did at approximately 12:36 a.m.?
So by looking at the timeline in the phone, we're able to see that Ms. Reed's phone auto-connected to John O'Keefe's Wi-Fi at his house at 12:36 a.m. You know this because it's a password-protected access to the phone, so you would have to know the password to get into this Wi-Fi network.
Now, I suspect that she already has his password saved because she visits John O'Keefe. Like, you know, when you visit friends, one of the first things you want is like, hey, what's the Wi-Fi password? So 12:36, she's back at John O'Keefe's house.
And that would be the home in 1 Meadows Avenue, correct?
Yes, that's correct.
And Your Honor, with the court's permission, if we could publish each of the 8 voicemails to the jury.
Okay. Are we going to hear which time each one is?
Yes, sir. And Trooper Greeno, again, similar to the other messages, just for point of reference, the earliest of the voicemails is the last in the list, and the most recent is at the top of the list. Is that correct?
Yes.
Now, as far as
Yep, this is the thing. Commonwealth is going to have to readjust their timeline, because if they're saying that killed him at 12:45 and he's back at that, and she's back at the house at 12:36, then I mean, this is another possibility. Maybe somebody else ran over John O'Keefe. Like, maybe he was hit by a car. Maybe it was some random person we've never actually heard. Right? Like, so, yeah, Lally said 12:45 in opening statements. I would absolutely ride this in closing and just be like, you heard, you know, Mr. Lally say that she killed him at 12:45, but then you heard from this expert who says she's home at 12:36. How does that happen? Does she have a time machine? So, yeah.
as this first voicemail, what time did this occur?
12:37 a.m.
And with the court's permission, if I could play that for the jury.
Yes.
Okay, if you couldn't hear that, she said, John, I fucking hate you.
Ms. Gilman, if you could have the second message.
Ow. Ow.
Sorry, Ms. Gilman, if you could pause right there, please. My apologies, Your Honor, I just wanted the siren to go by.
Oh, that's fine.
And before Ms. Gilman presses play again, Trooper Greeno, what time is the second message?
12:42.
Ms. Gilman, if you could. Now, Trooper Greeno, with reference to the third message.
Okay, that second message was, I don't know what that was. Sounded like footsteps.
What time is that received?
12:59.
And again, when I say received by Mr. O'Keefe's phone, is that correct?
That's the timestamp of the voicemail in his phone, yes.
And Ms. Gilman, if you could, with reference to that third message.
John, I'm here with your fucking kids. Nobody knows what the fuck you want, fucking pervert.
Now, the
John, I'm here with the fucking kids. Nobody knows where you are, you fucking pervert. This doesn't sound like somebody who thinks that she just killed him. It sounds like somebody who is really, really pissed off because she's stuck with the children while she thinks he's out banging some strange. Okay. This doesn't sound like a murder call to me.
Fourth message, Trooper Garino, what time was that received by Mr. O'Keefe's phone?
1:02 a.m.
Ms. Gilman, if you could, when you're ready.
That was it.
So can we just turn the air conditioner off for just
Okay, so the voicemail was nothing.
a second, please? So you just played it?
Yeah, Your Honor, there was no content. It was just like a 1 second long message.
Now I want pizza. God damn it.
And Trooper Garino, with regard to the fifth message, what time was that received by Mr. O'Keefe's phone?
37, 42, 59, 1:11 a.m. Excuse me.
And Ms. Gilman, if you could.
Yes, 1 in the morning, I'm with your fucking niece and nephew. You fucking pervert! You're a fucking pervert!
It's 1 a.m. I'm waiting with your niece and nephew. You fucking pervert. You fucking pervert. And I'm like, this again does not sound like, hey, I think I ran you down. This sounds like, hey, how dare you be off banging other people while you're supposed to be like, she thinks he's fallen dick first into some other woman. That's what's going on here, right? She's not like, hey, I think so yeah.
And the sixth message, sir, what time was that received by Mr. O'Keefe's phone?
1:18 a.m.
Gilman, if you could.
John, I'm going home. I cannot babysit Amy. I need to go home. You are fucking using me right now. You're fucking another girl. She's sleeping next to me. You're a fucking loser. Fuck yourself.
So I missed some of that. She's like, I can't be a babysitter right now. I'm going to take it down to 1 speed. We're going to try that one again because I couldn't get it fully.
Gilman, if you could.
John, I'm going home. I cannot babysit Amy. I need to go home. You are fucking using me right now. You're fucking another girl. She's sleeping next to me. You're a fucking loser. Fuck yourself.
So she says like, hey, I can't babysit. You know, I need to go home. You're fucking another girl, you fucking loser. It really does not sound like she thinks he's dead in a snowbank, right? And people are saying, oh, could she be calling him in order to establish an alibi? Like that she's calling him specifically so that, you know, so that she can use these voicemails later to say that she, like, if you were trying to create a voicemail string to try to false up some evidence to say that you were, that, you know, you didn't think the guy was dead, would you be calling him a fucking loser? Would you be calling him a fucking pervert? Would you be no. If you were trying to do that, you'd just be like, hey, John, when are you coming home from the party? I miss you. I love you, right? That's what you'd be doing. This makes no sense to me. This is like, I want to create like a false story to say that I was, you know, that I didn't run him over, but I also want to sound like a crazy person when I do it. And I want to sound no.
The seventh message, sir, what time was that received by Mr. O'Keefe's phone?
5:23 a.m.
Gilman, if you could.
John, where are you? In like desperate, panicky voice. Yeah, it sounds, you know, okay.
The last and eighth message, sir, what time was that received by Mr. O'Keefe's phone?
6:08 a.m.
Ms. Gilman, if you could. Gilman, if you could pause there for 1 second, I'm sorry. With respect to this message received on Mr. O'Keefe's phone at 6:08 a.m. From your knowledge of the investigation, where was the defendant, who, if anyone, was with her or around her at the time of this message at 6:08 a.m.?
Jen McCabe, Kerry Roberts. During the message, you can hear someone on the phone with 911.
Thank you, sir. Ms. Gilman, if you could.
Yes, I need someone to 34 years old, yes, now, so they can't now. Yeah. We're like, I don't see what is terrible.
I don't know what this is other than like incoherent noises. By the way, Coffin Daffer was saying that that Karen Reed was laughing during these texts. I did not see her laugh at all. I did not see her laugh. Yeah, this is the wiper call. Yeah, doesn't she look like she finds this hilarious? I'm not seeing it. Ooh, that's ugly. I'm just going to say, if Mrs. Runkle was murdered, I don't know that I would want to watch the trial. I think I would find that very difficult. And I don't know that I would want that. So The wipers kind of sound horror movie-ish.
Can we turn the air conditioning back on? Thank you very much.
Now, Trooper Garino, in addition to the 53 phone calls that you testified about the defendant made to Mr. O'Keefe from that time frame following 12:30 a.m. to approximately just past 6 a.m., did you note any other calls to a contact listed within the defendant's phone as mom?
Yes.
And when were those calls placed?
I believe there's one at 1:10-ish in the morning. I forget the exact timestamp. There's also one at around 4:40 in the morning, and then at 4:42, right around 4 in the morning. Two of them, the first two weren't answered, and then the third phone call was answered.
So she might have called her mom about how much John is a dick. Like, if she thinks that her guy is stepping out while leaving her with the kids, calling her mom isn't an unreasonable response.
Now, with respect to Ms. Reed's phone from that same time period, what, if any, phone calls did you observe to a contact?
All right, we're going to jump ahead a little bit here.
It shows that he's taking 170 steps, going 99.6 meters or 3.
So now we're looking into his health stuff on the phone, which is basically just tracking his steps, right? So
126 feet. At 12:21 in 10 seconds to 12:24 in 22 seconds, it shows 80 steps and 87.74 meters or 287 feet. At 12:21, 14 seconds to 12:24 and 37 seconds, it stated ascending, descending 3 floors.
Wait a second. What? Let's hear that again.
12:21, 14 seconds to 12:24 and 37 seconds, it stated ascending, descending 3 floors. And then at 12:31.
Wait, could that be him going like down some stairs? What? Now, he supposedly never makes it into the house, right? So, where the fuck does he find stairs? Where's he finding stairs at that point?
56 to 12:32, 16 in the morning, 36 steps, 25.46 meters or 85 feet.
Now, sir, with respect to what's listed as steps, does that indicate, from based on your training experience and familiarity with this sort of health data, what, if anything, does that tell you as to whether or not the person with the phone is physically taking steps?
That's not the case.
What is the case, sir?
Like I said, the phone has internal measures.
So basically, your phone can't tell if you're taking steps because your phone is not able to do legs. And that's kind of obvious, right? But if you're sitting there and you do this with your phone, it's going to think you're walking or something else. But it's going to think you're walking. So, okay. Fair enough. Let's move on to sort of the next thing he does here, which is this stuff.
As I said before, the range of accuracy due to satellite strength. So, as I said, it blows out as it loses strength, and then will come back in as it gets better signal.
Mr. Chairman, if I could have the next slide.
I don't know why they printed this out with the
What are we
Lexus
looking at
Nexus.
this as far as 12:25:31?
Same area where the 348 is. This is plot 351. Again, as you can see, strength of signal blows out, encompasses almost the whole neighborhood, all the houses around.
So the range of accuracy, I've got some questions about, but basically he's trying to say that the phone stops to show, John O'Keefe dead in the snow.
And Ms. Gilman, if I could have the next slide. And again, sir, is this the same GPS point of 351, number 351 at 12:25 and 31 seconds?
Yes, it is.
And if you could, again, just explain to the jury what we're looking at on the slide.
Same thing, just the degree of accuracy and the strength of the satellite signal to Officer O'Keefe's phone.
So 12:25, he's supposedly dead in the snow, but also went up and down 3 floors. And also you'll note that the circle encompasses the house. So this whole thing could actually be him not here, but him here.
Ms. Gilman, if I could have the next slide.
I'm just going to say, John O'Keefe gets a real workout post-mortem. This is weird.
And again, sir, if you could explain to the jury what we're looking at in this slide and what time frame you're talking about.
Yep, this is point 349, 32 seconds. Again, latitude and longitude, they're all right in the same area. And that's that.
Ms. Gilman, if I could have the next slide. Again, Trooper Guarino, is this the same GPS plotting point in the same time frame of 12:25, 32 seconds?
Yes, it is.
And again, if you could explain to the jury what we're looking at in this, in particular in relation to the earlier slides with reference to the accuracy that you were talking about.
Yeah. So again, the accuracy blew out as it lost signal, and now it's shrinking back in as accuracy gets better.
Ms. Gilman, if I could have the next slide. And sir, what GPS point or what time frame are we looking at in this particular slide?
It's 12:25 and 33 seconds. Again, same area, lat long, right in the yard of 34 Fairview.
And Ms. Gilman, if I could have the next slide. Trooper Guarino, is this the same GPS point of number 348 and 12:25 and 33 seconds?
That's correct.
And again, if you could explain to the jury as far as the accuracy and what we're looking at in this.
Yep. So I believe they actually wasn't that much of a drop off. Yeah. So it went from 88 feet to 72 feet. So the circle still doesn't look like it really shrank much.
Now I'm just going to point out that 72 feet is going to be within a certain amount of accuracy, right? It's not, I don't think that they can actually conclusively say it's within that sphere, but yep.
Ms. Gilman, if I could have the next slide, please. And again, Trooper, what time frame and what GPS point are we looking at in this one?
This is 12:25 and 34 seconds. Again, same thing right there, the corner of 34 Fairview and 32 Fairview.
Ms. Gilman, if I could have the next slide, please. Trooper Guarino, this is the same GPS point number 350, 12:25 and 34 seconds. Is that correct?
So the reason why he's showing all of these is basically to say we are pretty sure he was lying in the snow at that point. Okay. All right, we're going to move on a little bit. Just I need sort of a break at some point. I am running out of gas. The not sleeping is getting to me. So we're going to jump ahead to post break.
The probative value of this Google search outweighs.
Okay. So we're going to have an application, and I'm going to have some thoughts about this application, and I'm going to have some thoughts about Lally too. We're going to have some thoughts about Lally as well as this application.
All right, so Ms. Giannetti, did that give you enough time?
Oh, I had enough time. Yes.
Okay. All right, so Ms. McLaughlin, why don't I hear you just briefly If you could frame this, or Mr. Lally, whoever wants to.
Yeah, sure. The Commonwealth is moving to introduce a Google search the defendant conducted at 1:27 p.m. on January 29th, 2022. The Commonwealth would argue that the probative value of this Google search outweighs any prejudice to the defendant. The search in question is at 1:27 p.m. before the defendant had spoken to law enforcement. She conducted a search for DUI attorneys. The Commonwealth thinks that this is appropriate for the jury to hear, as it rebuts the Bowden defense of the defendant.
Okay, no, it's not appropriate. Under no circumstances is this appropriate. This is fucking insane. No, it's not appropriate. So let's talk about this. What is she trying to do? She's trying to get a lawyer. And why are they trying to present it? Because they want to suggest that she is guilty because she's trying to reach out to a lawyer. This is a line of argument that has been rejected for like all the years. Like if I had lived 3 of my lifetimes, and you go back like 120 years, so 1 year for every hour of Trooper Paul's experience, during none of those years would it be appropriate to make this argument that somebody looking for a lawyer indicates that they are guilty. This is a fundamental right. This is, and I'm just going to say, like, this is absolutely freaking crazy. So let's talk about what happens if somebody calls me. Let's say somebody phones me out of the blue and they say, hey, I need to talk to you about, legal representation. Have you ever handled a murder before? And I go, hey, we have a talk. And ultimately they decide that they don't want to hire me. They go and they hire somebody else, or they decide they don't need me or whatever else. And then it turns out that their wife is found dead. And so the thing is if they call me as a witness to that conversation, I could tell you how that goes when I get up on the stand. It'll be like, okay, so I sit down on the stand and they say, so did you have a conversation with so-and-so at this hour? Privileged. And they'll be like, well, we need to know. And I'm like, that's neat. Privileged. I cannot answer whether or not I spoke to this person. I cannot answer what the content of our communication may or may not have been. I cannot confirm or deny that I spoke to this person. You get fucked. That's what it is go fuck yourself. That's what I'm going to say, but in language of that's privileged and I decline to answer. And if it comes down to it, I'll be like, cool, throw me in a cell. Like that, somebody looking for counsel is privileged. That is, and so she's trying to do a more probative versus prejudice. I don't think it should even get there. It should just be, this is privileged, go away. Like, you should not be able to tender this. And frankly, they should know that they don't get to tender this, and they should know better than this, because if they get this in, if the judge had said, sure, you can ask about that, you can inquire about that, that would absolutely flip this on appeal. Like 100% she would be getting out on appeal, right? So, yeah. Yeah, plus it's DUI lawyer, not I need a murder lawyer. So it's kind of like she's looking, there's nothing about like, hey, I need it. But this request is absolutely fucking stupid. And I'm just going to say, Lolly, how dare you pass this off to your colleague? You should have the courage to make this argument yourself, because this is stupid. and you are making your, like, I don't know what their discussions were, but this is a bad look. It's a bad look to have your colleague argue this one and not you. Because it kind of looks like you're throwing her under the bus. It kind of looks like you are letting her make the stupid argument when really you should either do it yourself or not do it at all. I mean, maybe she volunteered. Maybe she wanted to do this, in which case she sucks. But I suspect that this, and the thing is if I had a junior lawyer working under me, and I assume she's a junior, I don't know for certain, but if I had a junior lawyer working under me who said, I want to make this argument, can I make this argument? I would say no. Because as the senior lawyer or the first chair, I've got a responsibility to prevent you from doing the stupid thing. And, you know, like, save you from yourself on that. I just like, no, this is gross. This is disgusting. And Lolly shouldn't have had, like, Lolly should not be sitting there like, you know, like a stick of butter watching her argue this. And she should not be arguing this. Like, all of this sucks. This is all ridiculous. And, yeah.
Has laid out, not that she did not intend to commit John O'Keefe. The defense has been that the defendant is essentially, what's been represented in opening court was framed that she had no intent or opportunity to commit these crimes. Further, that she was not intoxicated at the time. So the Commonwealth feels that the probative value significantly outweighs the prejudicial value. It goes to her state of mind at the time that the search was conducted. Further, it also rebuts that there was any impropriety in the police investigation, or that, as the defendant has put it, that the police did not search any or investigate any other potential culprits. It also would go to the defendant's consciousness of guilt at that time. This statement is before she voluntarily gave an interview with law enforcement. It goes to her state of mind prior to that interview. And so for all those reasons, the Commonwealth would suggest that that Google search is appropriate, and it's not a typical case where it's an invocation of counsel, where law enforcement had not engaged her, and it goes to her state of mind at that time prior to any police involvement, and further to rebut that there was any improprieties in the police investigation, or that they should have investigated anyone else.
All right. And I appreciate, Mr. Lally, you bringing this to our attention to give us time to look at it. Ms. McLaughlin, I appreciate that you provided a very strong limiting instruction proposal. I'll hear you, Ms. Tianetti.
Thank you. Your Honor, you had asked that.
Okay, so people took the comments strong, and they basically, some of the people on Twitter were saying that, oh, how could she say that it was a strong argument? That's not what she said. She doesn't say it's a strong argument. What she says is, she says, I've appreciated that you provided a strong limiting argument. What she means there is that Lolly has basically said, we're going to tell the jury that they can only use it for one very specific, exact reason, and not for any of the improper reasons. And here's the thing. Of course, the jury will use it for the improper reasons, right? Of course, the jury will decide this based on, you know, stuff that they just cannot possibly consider. This, if I could tell you how I would have dealt with this as a judge, if I was the judge here, I could tell you how I would have dealt with this. Commonwealth, I've heard your argument. Mr. Yannetti, I don't need to hear from you. I am denying your application, Commonwealth. You do not get to do this. Can we bring the jury back? Can we stop wasting time on this? Whatever the hell this is? So, yeah. Let's see what Yannetti has to say. Yeah. Basically, that's neat. No. Yeah, I've heard your argument. I don't need to hear the counter argument because your argument is garbage, and we're just not doing that. So,
proof of the phone call from Michael Proctor to my.
Oh, I didn't say proof. No, I asked if that was coming into evidence.
Okay, well, I'd like this marked for identification for the purpose of this argument, if I could.
Sure.
Show counsel.
Okay, so what he's doing here is he's basically saying, well, this call has no value, because he's saying, how did she know she needs a DUI lawyer if she's not drunk and driving and whatever else? And he's saying this has no value because Proctor calls her prior to this. And so the way she knows she's being investigated is she gets a call from the cop. Yeah. So, like, the probative value of that drops to just about 0 at that point.
It's been redacted.
Okay. So let's have it marked for ID before I hear you any further. So Madam Court Reporter needs to mark it.
Triple L for identification.
All right, and if I may have that. Thank you very much. Just give me a minute, Ms. Giannetti. All right, so this is just that a call occurred, right?
That a call was made from Michael Proctor's personal cell phone number, you can see the last 4 digits there, to my client at 1:19 p.m. on January 29th.
Okay.
Approximately 8 minutes before she calls to investigate a potential DUI attorney.
Okay, so focus on the law for me and tell me why I should exclude this.
Of course, yes. With regard to the cases that the Commonwealth has cited, I think the court has seen, one of them is an unpublished opinion, the other is a homicide case. They couldn't be more distinguishable from this case. With regard to the unpublished opinion, that appears to have been a gun charge where the defendant in that case did a search for a 9mm handgun on his cell phone. He did not ask for Google or search in Google for a handgun attorney.
And the distinction between, like, doing a search for handgun versus lawyer is tremendous, right? That's huge.
He made a specific inculpatory search that the court ruled was relevant, and it was not outweighed by the danger of unfair prejudice. In this case, we have a person being contacted by the police and then doing what a citizen has every right to do, which is to look for an attorney for representation. There's zero probative.
I'm just going to note here, the argument from the Commonwealth is basically, if this is granted, this basically annihilates the whole you can't use that somebody spoke to a lawyer thing, because how do people find lawyers in the modern era? How do people figure that out? Well, they get on Google and they search and it creates a record. So if that becomes admissible in court, then they're always going to do that, right? And the other thing is, like, does that mean we're going to recall every one of the Commonwealth's witnesses, every Albert and every McCabe, and just be like, hey, we're going to ask you about whether you looked for a lawyer? Because that'd be a thing.
Value to that, other than she's presumed to be innocent and she's seeking an attorney to defend that presumption of innocence. That's it. There's zero probative value. But there is
I entirely agree. There is no probative value.
Extreme and unfair prejudice in this case. Your Honor, the limited instruction that the Commonwealth has provided ask this court to instruct the jury whether her action in doing an internet search for an attorney indicates feelings of guilt by a defendant. I can't even believe that argument.
Let's just.
I agree with him. Like, yeah, I agree. I can't believe it was made.
Focus on the
Well,
law.
I'm trying to, Your Honor. I'm flabbergasted.
That is an argument on the law, right? The argument on the law is their position is legally ridiculous, right? Cielo, I can't turn on closed captions because closed captions are unavailable. I just can't do it. Sorry, I don't have them.
So what I'm going to do then is I'm going to stop you. So on the balancing act that I have to do, I find that the probative value is outweighed by the prejudicial.
Okay.
She's like, I don't like this argument, so I'm gonna, stop you from beating up on Lally. I'm like, Lally, if I'm the judge, I would have let him go off, right? But she's like, I don't want the drama. Just, I'm obviously not doing this. So, yeah.
All right, so I'm not going to allow it in, Mr. Lally, in your case in chief. Now, if you feel that through this witness or through any other witness, Mr. Lally, that it then is admissible, I just ask that you come to sidebar beforehand.
Absolutely, Your Honor.
Okay.
So, she says, I'm not allowing it right now, but later on, we might try to call it. And that I would have just said, it's just not coming in. Full stop. There is no circumstance in when this is coming in. Other than like Karen Reed comes up to the stand and specifically waives privilege or some shit like that, which, yeah. Okay, people want me to try closed captioning again. I'm going to try refreshing to see if closed captioning has loaded. Sometimes it takes a while for it to get added to a channel, but we'll see. Nope, we are still without closed captioning.
Stop you. So on the balancing act that I have to do, I find that the probative value is outweighed by the prejudicial.
Okay.
All right. So
and now it's
I'm not going to
letting
allow
me
it in,
fast
Mr.
forward.
Lally, in your case in chief.
Okay, what's going on here?
All right, let's. Yes, please.
All right, now we're going to move.
Computer networks.
So that course was through the NW3C.
I
They just
didn't
had
ask
it
you where it
multiple.
was from. I asked you whether one of the courses that you took was called Introduction to Computer Networks.
That's correct.
And another.
So, Lally right here, or sorry, not Lally, Yannetti right here is basically trying to tell the witness, you're going to have to answer the questions that I ask and not provide anything else. Now, I'm just going to say, I didn't think that the cross-examination for this guy landed a whole lot.
The course that you took was Introduction to Cell Phone Investigations, correct?
Yes.
Introduction to Previewing, correct?
Yes.
You hold no degrees in the field of computer forensics, do you?
I hold certifications.
You hold no degrees in the field of computer forensics or computer science, correct?
Like college degree?
Correct.
Yeah, correct.
You have no publications in the field of computer forensics, do you?
No, not yet.
And you've never.
No, not yet. Well, you know who else has no publications yet in the field of computer forensics? Me. I also have no astronaut trips yet. So, requesting a feed that has CC. The problem is if I switch to a different feed, then I no longer have timestamps. So that makes things a bit of a nightmare. Like I have not yet won any lotteries. I have not yet become king of the universe. I have not yet, learned how to shoot lightning. That doesn't necessarily mean that I'm going to learn any of those things, like that any of those things are going to happen.
taught a course in computer forensics, have you?
No.
All right. Well, as a Norwood police officer for 10 years and a Massachusetts state trooper for 9 years, you would agree that you've written a lot of police reports over the years, have you not?
Yeah, you can say that.
Prior to becoming a Norwood police officer back in 2005, you attended a police academy, right?
Yes, I did.
And at the academy, one area of focus was the proper way to write a police report, was it not?
Amongst others.
You were taught that it's important to write police reports close in time to the events in question while they're still freshest in your memory, correct?
That's not necessarily the case.
Okay, so is it your testimony before this jury that it's preferable to
I would take it, but it's a 120-hour course, and that's so long.
wait months before you submit a police report on something that happened months ago, sir?
Well, it depends on the data that I'm using. If I can't get into a phone, then yeah, I have to wait months.
But once the information is received that you need to write a police report, would you agree with me that it's important to record it in a report as soon as you can?
No, I stand by my previous statement that as soon as the data is available that I can do it, I will. And if, things come up, then, I do it when it's able.
So I think you just answered my question. You said as soon as the data is available and you've completed your investigation.
I never said I completed. I said if the data is available.
Well, let's say you've completed your investigation, sir. Are you going to argue with me that it's preferable not to wait to record that data in a report?
Objection.
Ask it differently, Mr. Yannetti.
You were also taught that it's important to include all the important details in your police report, correct?
Again, it depends on the report I'm writing.
Okay, so in other words, there are times when you're writing a police report when you intentionally leave out important details, Trooper. Is that your testimony before this jury?
Objection.
I'll allow that question. Is that what you do, Trooper?
No, ma'am.
Okay.
Your Honor.
So you would agree with me, going back to my question, that it is important to include all the important details in your report, is it not?
Again, it depends on the report that I'm writing. There's some data that goes in, there's some that doesn't. I can't have everything in. Again, for phone, I'm speaking to technically phone reports or cell phones, computers. I can't include everything.
So once again, we've got the Canton brainworm problem where suddenly people become super argumentative on cross. And this guy's going to have a whole lot of issues on that. Let's jump ahead a little bit.
On John O'Keefe's phone, did it?
How do you mean?
Well, didn't you indicate in your report that the extraction was not inclusive of all potential data contained within the device?
No, that's not true.
Well, the extraction that you did contained communications, iOS messages, phone calls, social media communications between John O'Keefe and Karen Reed, correct?
Yes, that's correct.
And it contained communications between John O'Keefe and Jennifer McCabe?
Yes, that's true.
It contained communications between John O'Keefe and Kerry Roberts?
I can't recall.
All right. But it did not include any communications between John O'Keefe and Julie Albert, did it?
Again, I can't recall.
And again, I'm talking about that initial extraction. That initial one didn't include any communications between John O'Keefe and Chris Albert, did it?
I only created one extraction of John O'Keefe's phone.
Right. That extraction report also did not include any location data, did it?
No, it did.
You didn't note any location data in that initial report, did you?
In the February 4th report?
Correct.
I didn't go through the data at that point.
All right.
This is just my extraction report saying that I got the phone, it was extracted and placed onto the server. And then I wrote, this report is not inclusive of all potential evidence, potential data contained within this evidence.
When was the first time that you reported on location data in this case?
I don't remember.
Wasn't until April of 2023, correct?
Oh, there was a reason for that.
Well, I didn't ask you if there was a reason for it, sir. You understood my question.
Oh, what a smug. Yeah. Yeah.
Didn't you?
That's correct. My first report regarding was in January.
We're talking about John O'Keefe's phone now here.
Yeah.
You did not report on the location data on John O'Keefe's phone until April of 2023, correct?
I didn't look at the extraction initially.
And you also did not report on any Apple Health data until the spring of 2023, correct?
Again, I didn't look at the phone extraction. Trooper Proctor would have looked at it. I would have loaded it and given it to him.
Okay, so Trooper Proctor had access to the phone first, and then you took care of it, correct?
He had access to the extraction that I would load into Cellbrite for him to look at, where you can't change the data. That is correct.
Okay.
Where you can't change the data. I don't know that that's true because it's data, but yeah.
And you would agree with me that you didn't address John O'Keefe's health or location data in any formal report until that April 23 report, correct?
That's correct. I never went through it.
Right, and you submitted your report in April of 2023 after you became aware of an affidavit filed by the defense expert, Rick Green, in which Mr. Green extracted and analyzed John O'Keefe's location data and his movements according to Apple Health data. Isn't that correct?
Yes, that is correct.
Before Rick Green submitted that affidavit, no member of the state police homicide investigation team, including you, had ever looked at or at least reported on the location data for anyone present at 34 Fairview, correct?
For the devices that we had, sir?
For John O'Keefe's device,
Yeah.
for Jennifer McCabe's device, etc.
I can't speak to that. I don't know.
All right, but you didn't, correct?
Again, I didn't look at the extractions until later.
Right. So you hadn't looked at John O'Keefe's location data in particular prior to Richard Green pointing out the location data in his affidavit, correct?
Again, I don't know. I wasn't asked to look for that data. When I did look at
On
it,
correct?
yes, there's no report until then.
Right. Same with Jennifer.
All right, so this guy kind of just, I don't know that Yannetti landed any real knockout punches, but this guy looks a lot more weaselly on cross than he did on direct.
Phone says 3 minutes earlier, correct?
Yes.
So if there's a 3-minute difference between the clocks, well, strike that. Do you know,
So this I wanted to sort of go through.
is it clear to you that those 3 clocks were not in sync regarding that one process number?
Yes.
In fact, the monotonic clock regarding this particular Waze artifact from John O'Keefe's phone says 2:22 a.m., while the baseband and display clocks have timestamps 3 minutes earlier, correct?
Yes.
So if there's a 3-minute difference between the clocks, well, strike that. Do you know, with regard to that 2:22 a.m. location data on Waze, do you know which clock Waze was using for that? Or the iPhone was using with Waze?
I don't. Didn't look through Axiom. I was using Cellbrite for that.
Okay. But certainly that would have been available to you had you looked at it, correct?
Well, but the artifact you show me is from the power log. It has nothing to do with the GPS, so it's not correct.
You could have looked at that exhibit, right?
Yes,
The information in that exhibit to see the 3 different clocks, sir?
Yes, but I can explain why this is incorrect.
All right, maybe Mr. Lally will ask you.
Sounds
All right? But you would agree with me if there's a 3-minute difference between the clocks and you don't know which clock was used to put John.
I kind of like that as a technique for dismissing him. Like, hey, you want to, you want to fill some stuff in. It's like, oh, maybe you'll get that on redirect.
John O'Keefe's phone on Oakdale Road at 2:22 a.m. That could explain. Let me just. It's not 2:22.
No, I know what you meant.
Mr. Jackson, thank you. I'm sure everybody else did. With regard to the 3-minute discrepancy between the clocks, and you've said you don't know which clock Waze was using to put John O'Keefe's phone on Oakdale Road at 12:22 a.m. That could explain the discrepancy between the Apple Health data and the Waze data, could it not?
No.
But as you sit here today, you don't know whether Waze was relying on the baseband, display, or monotonic clock, correct?
Again, can't be used for that.
Now, you're aware that Jennifer McCabe signed a
So he ends up looking like a bit of a weasel.
consent form on February 2nd of 2022 for her cell phone to be imaged.
Yes.
And a full forensic extraction was performed on that phone sometime shortly after February 2nd of 2022.
I don't remember the exact date. I didn't download her phone.
But in any case, you generated a Celebrite full file system extraction report on May 31st of 2022, correct?
Yes.
And you were aware that that Celebrite report was the one that was turned over to the defense in this case, correct?
That is correct.
But you'd agree with me that that extraction report didn't contain anything close to the full file system, despite the name on it, correct?
It did.
Well, that report was filtered to return only Jen McCabe's communications with Karen Reed, Kerry Roberts, John O'Keefe, and Kaylee Furbish, correct?
That is not correct.
Did Michael Proctor instruct you to pull only those communications?
Objection.
You didn't seek to obtain any of Jennifer McCabe's communications with her sister, Nicole Albert, did you?
I didn't go through, like I said, didn't go through Jen McCabe's info.
And you didn't seek to obtain any of her communications with her daughter, Allie Albert, did you? I'm sorry, Allie McCabe.
Objection. May we approach?
Sure.
Okay, so I'm going to stop him here because I think that that's basically all the interesting parts of him. We're now going to, I'm going to go through some super chats. We're going to swoop super chat, and then we're going to move on to our next expert, who is pretty cool. So swoop. So Jennifer S., thank you for the membership. Cindy Collins, thank you for 5 gifted memberships. Rainman YYC, thank you for 10 gifted memberships. L. Fliggins, fingers crossed for your reserve verdict. Fingers crossed. Ryan Smith, please tell us how you'd cross Emmy regarding IV. We'll get there. So Ella, thank you for 10 gifted memberships. Laura Christine, thank you for 10 gifted memberships. Cindy Collins, thank you for another 10 gifted memberships. Very generous. Outside the Box, thank you for the gifted membership. Rainman YYC, reciprocal discovery is just another symptom of Massachusetts brainworm infection. Thank you. Greg, I'm ahead here, but do you think the ME opened the door for the federal witness to provide opinion number 4, as we've been calling it in Discord? I'm not sure. I don't think the judge is going to allow it, but we'll see. Muttley9991, thank you for the membership there. Just because, for those who watch Murdoch Mysteries, Dr. Russell is basically Dr. Julia Ogden, but real, and didn't do the psychology career, but was a cop instead. Fair enough. I haven't seen the show. So, Mr. Sharpie, software dev has an idea called Remove the Duck. Add something unimportant to your project so your boss can remove that instead of something you care about. Did defense do that with accident testimony from the first expert? Kind of. They were willing to give that up. The Great Big Geek, ever see Hoodwinked? I have not. She reminds me of Red's grandma. Fair. Just because, okay, I missed the psychology. She's full Dr. Ogden plus law enforcement experience. There we go. Ian Paler, the most interesting grandma in the world. Yep. Mary Lewis, everyone here is an underachieving loser versus the doc. I kind of feel that. Yellow Pill NP, I bet she doesn't drink White Claw. Thilo Agde, I have a psych degree from Boston University. It has been extremely useful in my law career. I have a psych degree as well. I agree, extremely useful. RK, thank you for the YouTube membership. Amy Louise, thank you so much. Rainman YYC, I've been bitten by a pit bull, 1 bite and rip, 18 stitches in less than a second. Pit bulls are, they can be nice dogs, but they got nasty teeth. Hi, bye password. Oh, thank goodness. Runkle is live. I have things I need to do, and listening to this helps so much. This super chat is my motion for Runkle to please get 2 additional hours of sleep on one if any day. I don't know when that's going to happen. I'll tell you one thing. Am I going to embiggen? So, I had a court hearing today, and it was an important court hearing. And so to get sleep on that, I made sure I went to bed to get a full 8 hours of sleep. And then I didn't get to sleep for 2 hours. And I woke up an hour early because my brain started arguing the motion in my head before I even woke up. And that woke me up like with the arguments ready to go. And I was all fired up and eager and yeah. So, sleep is something that is eluding me in the worst ways. But yeah, my brain already starting to argue things. I was like, yeah. Steve A, I might have missed it. Sometimes it doesn't catch things if they're too early pre-stream, so it might have gotten missed. I'm sorry, Steve A. Please just put it as a regular chat, and I will try to catch up when we can. Anne Bell Feinstein, when I get a service dog, I want it to be a Belgian Malinois. They're wonderful and very protective. No one messes with a Malinois. I certainly wouldn't. Mickey, loved Judge's reaction when the doctor referenced the puncture holes in the sweatshirt. Auntie Bev did a double take. Say what? Yep. Casey Cat, here for the Stark and the Runkleisms. Always. Thank you. Casey Cat, I was attacked by a pitty while walking down the street. My injuries looked just like that. Punctures where he grabbed on, then drag marks where he was losing his grip. Then it got infected because teeth. Ooh, I'm sorry about that. Just because, again, I want to point out that Terry Kuhn testified about the lack of dog DNA on day 12, which was May 15th/16th. That could well have caught her eye. Yep, absolutely. Tough Cookie, thank you for 5 gifted memberships. Much appreciated. Reasonably long name. Do they have a bite history for the car? Yellow Pill NP, with all of her achievements as a woman succeeding in a time when we weren't accepted as equals in medicine and law, he really thinks this gives her any time or kind of clout that outshines it all. right? I kind of feel like, and not just medicine and law, but policing. She became a cop in the 70s, a female cop in Boston. I feel like that might have been a tough time to become a female cop. So yeah. Just saying. Just saying. It's a big one. Casey Cat Ian, where do we buy one of those Lexus Road Sharks? I want one, especially for road hour. Shark. I don't know. Lou M. Runkle, this is like me, smirk. The Great Big Geek. So Runkle knows what a unicorn is, but not a GGPP. I don't know what a GGPP is, so I feel like that might be something I don't want to know either. Cat W, motion per Runkle storytime swooper sound. Okay, I might have to make one. Rainman YYC, maybe Bev just wishes she never moved from the well to the bench. Fair. Carson Pratt, Judge Bev instructing Lolly sounds like Pink. Just give me a reason. Just a little bit's enough. Fair. Rainman YYC, I still say it was a mimic in Lexus form. Solid reference. Carson Pratt, watch Lolly open the car's doors accident and cross. He might. Mama Meme, what, if anything, did your expert know about car accidents, Lolly? Certainly not as much as this lady. Shameful. Elf Liggins, I think CW will, or the Commonwealth will get a canine handler to rebut Dr. Russell. In my experience, attacking the accused, that's not a dog bite. Maybe we'll have to see. Marissa, if I weren't married, fire. I think that there was a lot of people about that one expert. Mavia, maybe these guys can reconstruct why the Leafs suck. Solid sports burn, but I'm not following sports. So, Sandy, thank you for 10 gifted memberships. Much appreciated. Blackjack Gaming. This guy whipped out his expertise and it made a thud on the floor. Sandy, thanks for doing these recaps. They're great. Thank you, guys. You make it all possible. DSN says, thanks for the membership. Thank you, DSN. And thank you for the gifted membership. Carson Pratt, I should probably use this so I don't lose it. That's the member chat. Yep. Blackjack Gaming. This guy doesn't even have an associate's degree. Yeah. That would have been a fun question from Lolly. Isn't it true you don't have any associate's degrees? Man Bear Pig. Does Lolly enjoy baiting and flop sweat? It has to be a kink for him to pursue it so doggedly. I'm not going to speculate on his kinks. Tina, I guess my GAD and I will just go home. I mean, that's impressive too. Char Diem, thank you so much for the YouTube membership. Marmar, get him to design you a chair since you sit wrong. I think he might be out of my price range. Just saying. Dr. Tapioca Weasel, fun fact chat. Super chats dodge the you must be subscribed for more than 5 minutes to participate in chat nonsense. Because, capitalism. I'm okay with that because, capitalism. My goal for the channel is to have the channel support me doing free law, right? Doing pro bono law. So, and I don't get there without being at least a little bit of capitalism. So, I got to, GGPP for the Gorilla Grip. Yeah, I get you. Yeah, no. So, yeah, I mean, I got to do some capitalism in order to make that happen so that I can be, I guess, it's a little bit socialist if I'm doing free law. Not really, I guess. I don't know. So, Commonwealth, Dr. Aaron said can't determine cause, and Bev said Dr. Rentschler can't testify on cause, so who will? I don't know. M.A. Esquire and Andrea's chat said the law doesn't require the MD. I couldn't find it either. Johnny O, am I the only person who thinks that Lolly owns a bong and uses it frequently? I don't know if he owns a bong. John BB Boot, can Ms. Little ask the ME on cross if any pressure from Proctor Buchanan on manner of death or why they refer to her as a whack job in their texts? I think they might. They'll definitely ask about pressure. Skeesy, am I on delay? That taillight identifies as a ninja, or am on delay. Alba Gamer 82, thank you for the membership. Much appreciated. What, if any, side quest are we sort of on? Did the definition of laughing change or something? Steve A, this is true. I used to get thousands of steps and hundreds of flights of stairs when on a motorcycle. Because you're doing the, especially if it's a Harley, I guess. Rachel Duick, cheers to 14 months of educational snark. Thank you for being along for the ride. Forever Wander 03. Oh, and by the way, when this is done, what am I doing? I'm recording a video on Baldwin. So no rest for the wicked tonight. Forever Wander 03. Was Lolly maybe trying for a mistrial? I don't think he was. What, if any, side quest are we sort of on? But Brian Laundrie getting a criminal attorney right around Gabby Petito's death was used against him. It shouldn't have been. Dalai Lin, if you were an attorney on this case, would you prefer to represent the Commonwealth or defense? Defense is always more fun. It's always more fun. Can you share yours and Mrs. Runkle's space story? Basically, me and Mrs. Runkle both applied to a thing that hoped to send some ordinary people to Mars. I was rejected right off, and she was accepted for round 1, and then the project fell apart. Steve A says, updated / corrected expert timer, 104:50:30, and it looks like I missed 10 gifted memberships from Cindy Collins and 10 gifted memberships from Jack Druger. So thank you guys so much. What is it? Law and Lumber says, I was quiet until Ian said, my brain was arguing my motion in my head, and that woke me up, and I felt seen because same all the time. Isn't that the worst when you just wake up and your brain is like, I am ready to go, and you're sitting there like, I am ready to be still asleep, brain. Like, stop it. But nope. Hollyberry says, yay, capitalism. Kissy Kissy, thank you for the 5 gifted memberships. Krista Bolster Robichaud, thank you for the membership. Thank you for joining up. Wanda D, so much respect for your pro bono goals. They're big goals, but I'm crazy that way. Dina Kawaji, thank you so much for the gifted membership. Much appreciated. Okay. So, yeah, I mean, that's kind of it. It was worth applying. Maybe it would have happened, but we both kind of knew it was a long shot. So, yeah. I've got some Mars One sort of stuff. It would have been a cool idea. It would have been cool if they made it happen, but they didn't make it happen. So, all right. Let us jump forward to our next expert. And that is her. And she is super, super controversial because of her clothing. People had opinions about how she's dressed. And I suppose it'll make more sense when I talk about this if she's actually on the screen. That would help. So, some people did not like that she's there in a tank top, that she's got a nostril piercing, that she's got a tattoo that says, you know, K on the one side. And the tattoo that I thought was really impressive is this big skull tattoo. I'm like, I think that is an awesome tattoo. And you know what? If I was a pathologist who did, Amy, I skipped an important part. There's always important parts. Sometimes they get skipped. I don't know which important part you're referring to. Thing is, I don't hate this as court dress. I just don't hate it. I don't hate it. I mean, I think she's fine, right? I don't think there's any issue. I love the tattoo. The tattoo is fantastic. So yeah, I mean, I kind of get the sense that she likes showing off the tattoo, and cool, I would too. And Rob, thank you so much. Yeah, the other thing is how she's dressed doesn't really matter. Now, I'm just going to say I do criminal law. If my client shows up like this, I don't hate it because my clients have shown up dressed so much worse, so much worse. And they're always complaining about the air conditioning there. So I'm not gonna throw shit at this. She's not we can't like. There's no cleavage shown in with this outfit. There's no anything. We just see her shoulders. I got no issue.
History background, if that's all right.
Yes.
Starting with your bachelor's degree, where did you go and what, if any, area did you receive a degree in?
So I went to SUNY at Stony Brook in New York. I was a double major in biology and Germanic languages and literature. I graduated with a...
Okay, one of those degrees is going to be helpful today. I was a double major in biology and dramatic, literature. It's like, okay, you're going to testify about one of those two things today. That's it.
Bachelor's of Science degree. After that, I went to the American University of Antigua for medical school, and I graduated with honors, magna cum laude. After that, I did a 4-year combined anatomic and clinical pathology.
All right, so one of the, a skull tattoo, not on the face, good to go. So a lawyer I've worked with in the past has a dream. It's not me, but he's got a dream. And the dream is, Megan, you did miss that. That was on an entirely different day. We're covering day 28. We covered that earlier for day 26. That was back on Monday. So you did miss it, but that was a few days ago. So this lawyer wants to become a judge. And I'm not going to name him because I would probably screw up his plan. The instant he becomes a judge, his plan is, once he's actually on the bench, he's going to get a neck tattoo. So that's his goal, is to be the first judge with a neck tattoo. And you know what? I'm kind of okay with it. I think they would have a hard time bouncing him from being a judge for his neck tattoo. So, yeah.
Residency program at NYU Winthrop Hospital in Long Island, New York. After that, I did a 1-year forensic pathology fellowship at the Boston office of the chief medical examiner. And after that, I did a 2-year neuropathology fellowship program through Brown University at Rhode Island Hospital.
And doctor, are you board certified?
Yes, I am board certified in anatomic pathology, clinical pathology, forensic pathology, and neuropathology.
And if you could just explain to the jury a little bit about what does board certified mean?
Board certification means that every medical specialty has their own board. So for example, the American Board of Pathology dictates whether or not you can be board certified based on certain criteria. So you have to meet certain criteria, meaning that you have to complete a certain number of surgical specimens, a certain number of autopsies. And then once you meet that criteria, you can take an exam, which if you pass, leads to your board certification.
Now, if I could ask you just a couple, and your board certification is up to date at this point, is that correct?
Yes.
In each of those areas that you just spoke of?
Yes.
Now, if I could ask you some general terms as far as if you could define them for the jury. First of all, what is pathology in a general sense?
Okay, so she seems actually, surprisingly, given that Lolly is calling her, she seems eminently qualified at what she does. And when you're going to see that more when she gets into the discussions of, when she gets into discussions of what work she does. I think she's a great expert. I think she did fantastic. Somebody on Twitter was upset that I referred to her as the brain chopping expert because, it's funny. But she's actually she's actually excellent at what she does. Like, she's a fantastic expert. I would be entirely fine with this expert, tats and shoulders and all. So I give her like all the points. She's fantastic. So let's have a look at some of her brain choppery testimony. And the thing is, I suspect she'd find that funny. So, yeah.
Now, are you familiar with some terms in relation to injuries that you would observe as far as from a neuropathological
Dude, I've said that about a
as far
bunch
as
of different
injuries being
experts,
acute,
so
subacute,
y'all
or
can
remote?
go F yourself.
Yes. And can you explain to the jury sort of what those are and what those mean?
So it depends on circumstances. Acute generally is something that happened within a very short time frame. So when I refer to something as being acute, I usually refer to that as something that's occurring from the time of an injury to maybe a day or so afterwards. As I said, it's variable dependent on circumstances. Subacute is something that has not happened within the last few minutes, few hours, maybe even a day, and maybe something that is now in the process of healing. And then chronic is usually something that has happened a while ago in the past. You may see some sort of evidence of some type of injury in a chronic state. You may also not see any evidence because it may have completely healed by that point.
And so from your analysis in this case, how did you characterize, in your opinion, from everything that you reviewed as far as the injuries you observed in Mr. O'Keefe's brain?
The injuries I observed were acute injuries, meaning that they probably occurred minutes to hours.
Now, if I could turn your attention.
Now, I really wanted to hear her testify about whether or not she inspected any of the other witnesses to see if they had brain worms. Like, did you perform a brainworm check on Jen McCabe or, Higgins or any of them? Like, could you just tap and see if there's the brainworms? Like,
To your findings as far as when you conducted your analysis and your testing in this particular case, what, if anything, did you find as far as injuries to Mr. O'Keefe's brain?
So when I look at the brain, what I do is I look at all surfaces from all sides. And one of the things that I look for is anything grossly obvious, meaning anything I can look at the brain and see that there's something there that shouldn't be there. So one of the first things I noticed was a subarachnoid hemorrhage. And subarachnoid hemorrhage is something that occurs when you have bleeding within the leptomeninges. The leptomeninges are a very thin membrane that encase the brain and the spinal cord.
So you see, unlike Trooper Paul, she's very comfortable talking about her findings. She's very comfortable explaining things. She does a good job here, right? She's doing an excellent job. And what is she telling us? She's telling us basically, dude got smoked real hard in the back of the head, and it caused all sorts of problems, including a brain bleed.
And there should not be blood freely floating within the leptomeninges. So
yeah, you should not have the blood in the brain. That is a bad thing.
So if you have a subarachnoid hemorrhage, most of the time the causes are either a ruptured aneurysm, which is something I would see upon cutting the brain, or some type of trauma. So that was the first finding.
Can I stop you there just for a second? Of those taking notes and for our court reporter, could you spell the type of hemorrhage and the membrane?
Yes. Subarachnoid is SUBARACHNOID. And leptomeninges, LEPTOMENINGES.
Thank you very much.
You know how much it sucks right now when you're on the stand to suddenly have the judge be like, spelling bee. Can you spell the big long 16-letter word? And she's just like, no problem. I got that. Nailed. Nailed it. I don't know if I would have gotten that. So good for her.
Much.
You're welcome.
Now, with regard to anything related to the aneurysm that you indicated that you would have seen, what, if anything, did you see during the course of your review or testing or analysis of Mr. O'Keefe's brain?
So aneurysms are typically seen in the cerebral vessels that sit around the base of the brain. So there's something called the circle of Willis, which is the main arterial supply. It sits around the base of the brain, and it's kind of shaped like a circle that has vessels that come off that extend to other areas of the brain. So typically, if there is an aneurysm that is ruptured, it's going to be located somewhere in one of those vessels. So upon observing those vessels, I did not see any evidence of any aneurysm or any sort of natural disease state that might have led to a rupture in one of these vessels.
Now, I don't think Trooper Paul would have succeeded if he was asked to spell stuff or things or the like. Yes, Megan Fox has been covering Owens versus Eckerd, which is a fantastic, she's been doing fantastic coverage. It's a wild case. I wish I had the time to also cover it because the results on that one were crazy. But yeah.
Also, sometimes these vessels, since they do go deep into the brain, you may only see the rupture upon cutting the brain. And I did not see any evidence of any rupture of any of these vessels anywhere in the brain.
Now, as far as the subarachnoid hemorrhage that you observed, where was that located within the brain, if you could?
So the subarachnoid hemorrhage was on the frontal poles, which is essentially right here in the front of the brain. So the frontal lobes obviously sit in the front, and then the poles are the very frontmost portion of the brain. So it was on the frontal poles.
Bez, I gotta
It was also
respond to
on
your
the
email.
left temporal pole. So the temporal region is right here in the temporal region. And because of the way that the temporal lobe is shaped, it kind of has a little loop right in the front. So it has a pole as well. So it was on the left temporal pole. And then it was also in the left lateral fissure. So you have a frontal pole here. You have the temporal lobe right here, and then the lateral fissure goes kind of in between the temporal and the frontal lobes. So you have the hemorrhage here, and then hemorrhage right there. So it's kind of all concentrated almost in one area. But then there was also hemorrhage of the posterior surface of the right temporal as well. So on this side.
Now, doctor, I'm probably going to butcher this horribly, but just as far as the bilateral unci, are you familiar with that?
Yes. So the unci are the medial portion of the temporal lobes. So
Did you see how she just kind of like low-key corrected him? He's like, the bilateral unci, and she's like, well, the unci. Yeah, I thought that was kind of funny. She's like, let me just correct you. Just like, what? I thought she was a great witness. She knows exactly what she's talking about. She's clear. She is everything that, everything that some of the others weren't. So, yeah.
So it's like a bruise, hemorrhage, bruise, contusion. They're fairly similar. Some people use them interchangeably, but it's essentially blood that's no longer contained in a blood vessel.
When something is termed medically, based on your training experience, as a diffuse hemorrhage, what does that mean?
So diffuse means it's over a very large area. It's not something that's just a tiny little area. You could say, okay, I'm looking at this person's, let's say, liver, and there's a 2 by 2 centimeter hemorrhage sitting right there in the right lobe of the liver. Diffuse would mean there's hemorrhage throughout nearly the entirety of the liver.
Now, with regard to, you made a note as far as there being a diffuse hemorrhage within the pons, P-O-N-S, is that correct?
Yes.
Can you explain to the jury sort of what that means and where is that located within the brain?
So the pons is part of the brainstem. So the brainstem starts right in the middle of the brain, and you have the midbrain, the pons, the medulla, and then it turns into the spinal cord. So the pons is kind of in the middle of the brainstem.
I'm just going to say one of the things that really sucked about taking neuropsychology was the portion of like the neuropsychology exam where they had a brain up on the screen and they would point to a part of the brain, and then you had to write down what part of the brain it was. And you know why that sucked? A, because it was really hard to learn all the parts of the brain, but B, that was the moment when I realized I really needed glasses, because I got slaughtered in that exam. I got slaughtered in that exam because I just could barely see the brain properly. So, yeah.
And when you have hemorrhage in the pons, in this circumstance, it was because there was the herniation of those unci, which began moving closer and closer towards the pons, pressing on it, causing hemorrhage, because now the tissue is compressed. The blood is not going to be able to flow in and out freely, therefore hemorrhage.
Okay.
Now, with regard to the totality of what you reviewed in this case in regard to Mr. O'Keefe, do you form any opinions to a reasonable degree of medical certainty in regard to the injuries that you observed to Mr. O'Keefe's brain?
I was able to determine that these are acute traumatic injuries. I know that based on what I observed and in combination with the autopsy findings, that this is due to some type of trauma.
Thing hit him in the head. Thing messed up his brain. That is not good for the brain. This kills the crab. So that is basically what that is about.
If I could ask, as far as you have certain findings as far as an intraventricular hemorrhage and occipital horns of the lateral ventricles, correct?
Yes.
If you could please explain to the jury what
They're not going to bounce the
Yes,
witness
so
for a dress code
The
violation.
ventricles are almost like a tunnel system of the brain in which the cerebrospinal fluid flows through.
All right, we don't need to hear about everything brain related. Let's talk about what this matters for the. Let's talk about what matters for how this matters for the case. Well, John O'Keefe dies in part because of a brain injury, a very serious brain injury, and in part because of the cold, because he has the very serious brain injury, and then then he's left in the cold for a while, and cold is not good for him. So, yeah, I don't think that she's a great witness. She's fantastic as a witness. But her testimony doesn't really mean much because she doesn't really get us closer to a conviction other than by simply establishing that, yes, John O'Keefe has died. That's about it. So that's about it. So we're just gonna move on here to the next witness, and that is her.
That the testimony you shall give to the court and the jury in the matter now pending shall be the truth, the whole truth, and nothing but the truth, so help you God. I do. Thank you.
Good afternoon, Dr.
All right, before she does, we will swoop. And I got to read some super chats. What, if any, side quest are we sort of on? Judge Bev the other day said they could dress comfortably because it's hot as well, or hot as hell. I got to say, I've been in hot courtrooms, and when you're doing a thing and you're in robes or you're in a suit, it sucks. If they said you could dress comfortably, I'd be there, maybe in a Canton Brainworms t-shirt. So Caitlin Nadine, Massachusetts, one of the few states where continuing legal education for attorneys is not mandatory. Hello, Lally. Actually, that might make a decent state for me to try to challenge the bar exam in then, because if you don't have to take mandatory CLE, then that is easier for me as a foreigner to hold on to that. Timothy Turrigan, not a shoulder guy, Ian. I mean, they're all right. Emma Zay, no rest for the wicked, but do take lots of naps / breaks. That's still a good rest for your raging, vivid brain. Thanks for your fab legal and personal insights. I try to take naps where I can. My favorite lunch is to go have a nap. And somebody says, I would buy a Canton Brainworms t-shirt. The good news is that occasionally Against the Tide is posting a link to my Zazzle store where I do have a Canton Brainworms t-shirt for sale. So great news, that is available. So cool. Billy's Momzilla, it's hot. She's got creds. Beautiful top. First knowledgeable witness. Back off critics. You heard her. SK says, best point I've ever heard. If someone has a lot or big good quality tattoos, they must be someone actually relatively successful just because of the cost of getting good tattoos. The other thing I will note is that there's certain jobs, and especially certain amounts of like when you are the badass at your job, that allows you to show off tattoos. Because when you're like, hey, I am the low person on the totem pole, maybe you can't show off the sleeves. But when you're like, I am the senior partner, you can do what the hell you want. I just appreciate some good ink, even though I don't have any. So what you'll see sometimes is like senior partners who just like show off their tattoos. So it's a thing. Connie J says, Runkle, I don't hate her look, but I found it distracting, i.e. checking out her fascinating tattoo. That's entirely reasonable. Fair enough. Jeremy Morton, catching up, starting at street level as well as ending there is interesting for an odd number of flights. Maybe there was an extra long stare and the phone thought it went 1.5 normal floors. That's often something you found going into a basement. Okay, let's carry on here.
Doctor.
Good afternoon.
Oh, wait, I got to do another swoop. Also, I'm just going to note that anybody who works doing autopsies or pathology or that sort of thing, They have a little bit more freedom about wearing tattoos or whatever else. And that is largely because the customers are very unlikely to complain. They just, they don't file complaints.
All right, Mr. Lally, whenever you're ready.
Good afternoon, Doctor.
Good afternoon.
Could you please state your name and spell your last name for the jury?
My name is Irene Scordeballo. My last name is spelled Scordi-Bello.
And how are you employed, ma'am?
I am employed as a medical examiner.
And for whom are you employed?
I'm employed by the Office of the Chief Medical Examiner for the Commonwealth of Massachusetts.
And how long has it been that you've been medical examiner for the Office of the Chief Medical Examiner in Massachusetts?
I have been with OCME in Massachusetts since December of 2016.
Okay, so she is finally the medical examiner. And the really sad thing is that we don't actually get to her cross-examination yet. Because I want to hear her cross-examination to hear about, like, did you get hammered on, by Trooper Proctor saying, hey, you need to change your findings. Megan Fox says, I like watching tattoo artists. I do not and will not get a tattoo. I've contemplated getting a tattoo, but the rule I have is that when I think I might want to get a tattoo, I wait a year. And if I still want it in a year, then I'll get it. And so far, no tattoo has passed that test. Although one came close. I had to think about it. But no tattoos yet. So I can't say I won't. I actually thought about getting a tattoo for the citation for my Supreme Court win. I may still do that one of these days. So I may do that just to be like, yep, I got my Supreme Court wins tattooed on me. So, all right. We're going to jump ahead to some of the key moments of her testimony.
I may have on that deceased individual.
Now, as far as the manner of death, how are you making that determination?
The manner of death, as I mentioned, is circumstance dependent. I make that determination based on.
I will probably be on Friday Night Frenzy tomorrow. I will probably do a live on Saturday. So I'll probably do my own live on Saturday.
Investigative information that is provided to me by law enforcement, by the people who did the investigation.
And what, if any, legal determination are you making as far as when you classify something as either of those 5 categories in a manner of death?
I am not making a legal determination. I'm making a medical determination.
And so as far as the medical determination as manner of death, specifically when I'm talking about something that could be ruled or listed as manner of death as accident, is that, what if any determination are you making as far as that is concerned?
I'm making the determination that the information that I have either shows no evidence or very little evidence that the injury that led to the cause of death was intentional. So I don't have any information to suggest that that was an intentional act.
Okay, so she basically says, I am sorry. I don't have anything that says this is intentional. Now, lots of homicides are really obviously intentional, right? You find somebody who was shot in the back of the head. Probably wasn't an accident, right? Because it's really difficult to accidentally shoot yourself in the back of the head. Now, there might be some additional information that says, hey, this one is an accident. Like you hear that it happened, when somebody else was, whatever. So she's saying this could be an accident, could be intentional. And that's not necessarily uncommon with motor vehicle collisions, right? Because most motor vehicle collisions are accidental in the sense that most people aren't deliberately trying to run people down with their car. So the vast majority of people who get run down with a car are, just people who were just walking. Like, hey, I'm walking here, splat. That's kind of, that's kind of more often than not when you've got pedestrian injuries. But when you've got somebody but it could be intentional. It could be that it's somebody who's walking down the street and then suddenly, somebody who hates them sees them and is like, screw this person, and runs them down, right? So, yep, it's not super unusual, but it is still really bad for for the prosecution on that. Okay, so let's move on to some other stuff here. We're going to zoom through her because ultimately what she says is basically John O'Keefe is dead and we don't know if it's a homicide. Cool.
It's provided with records from the hospital where he was first taken by.
Usually a fight that causes death will be classified as a homicide. So, yeah.
Emergency medical personnel. And during the course of the autopsy, of course, I forgot, I didn't mention this. We also, during the autopsy, collect fluids from the body that are sent to the lab for toxicologic analysis. And after a few weeks after the autopsy, we get a report from the toxicology lab. And in this case, I looked at the toxicology report. As I mentioned, all the information from the investigators, the autopsy findings, the neuropathology findings, and came to a conclusion as to the cause.
Now, as part of the documentation that you received from the investigators, did that include photographs of the scene as well?
Yes, it did, some photographs.
Turning back to the toxicological findings that you received, what, if any, indication did those findings have, or did they indicate in regard to blood alcohol concentration with regard to Mr. O'Keefe?
Mr. O'Keefe had alcohol in his system, and I do believe, I don't have the toxicology in front of me, but in his blood at the time of autopsy, the level was 0.21 grams per deciliter.
Now,
0.21. So that's a lot. I'm just pulling up a blood alcohol chart just to sort of let us know. 0.21 is like well into, well into intoxicated. I think it's actually, that suggests around, what was his weight? 180-ish. That's around 10 drinks. That's around 10 drinks in. This puts you into the range, assuming that John is not a seasoned drinker. And seasoned drinker is a euphemism you will hear from lawyers. Lawyers love the term seasoned drinker because seasoned drinker means alcoholic. It means that you have enough of an alcohol tolerance that you are been over 200, 210. Okay, then it's more than 10 drinks. So seasoned drinker means alcoholic. And it means basically somebody who is going to be less affected. Now, I don't have any indication that John was a seasoned drinker. So assuming he's not, that blood alcohol content puts you into the range of severe impairment. Places where you'll be throwing up, places where you may be having trouble walking, places where you may be having trouble talking clearly, where your coordination is bad, where your ability, this is a pretty pickled sort of situation, right? So, yeah.
Contained within those toxicology findings, there's also
it affects
something listed as
judgment.
vitreous humor. Is that correct?
Yes.
And can you explain to the jury sort of what that is, where that sample is taken from, and why?
Yeah, that sample, the vitreous humor, is taken from the back chamber of the eye. It's one of the routine samples that we take in addition to blood from the body and urine. And it's again, used to look for the presence of different drugs. In cases of alcohol intoxication, sometimes we will get a value for the vitreous, and sometimes that value might not be exactly the same as the value that we get for the blood. It gives us an idea of where in the curve of alcohol metabolism, the individual is.
And so based on sort of the disparity between the vitreous humor level and the, I'm sorry, I may not have asked, what was the level in the vitreous humor?
I believe it was higher sorry, I just have to find it. I think it was 0.26. I'm sorry, I can't find it in his notes. I don't know if you have the, yes.
Oh, yeah, copy of toxicology.
Yes, it was 0.28.
0.28, by the way.
Now, doctor, with respect.
0.28 is getting close to the point at which you're starting to run into like life-threatening, where the alcohol itself might kill you. So 0.28 isn't quite there yet, but it's getting pretty close.
Back to the disparity between what was contained as the VAC in the vitreous humor versus the other number from his blood. What, if anything, does that indicate to you as far as, or what, if anything, do you take from it?
That suggests that the level in Mr. O'Keefe's blood had been higher than 0.21, and that's reflected by the 0.28 that was in the vitreous.
Okay, so let's explain this a little bit. What is the vitreous humor? It's like the goo in your eye. You have two kinds of humors in your eye. One is the aqueous humor, which is sort of in the front, and one is the vitreous humor, which is towards the back. This is eyeball goo. If your eye gets punctured, it is the goop that will drip out. So why is this helpful to get the blood and the vitreous humor? Well, because your vitreous humor's alcohol concentration changes slower than your blood's alcohol. So if you have a high blood alcohol concentration and your vitreous humor is not full of booze yet, then that suggests that you are still on an upward peak. You're getting drunker, right, over time. Whereas in this case, his vitreous humor was at 0.28 and his blood alcohol content is at 0.21, which suggests that he is getting less drunk. He was in the process of sobering up, as when he died. So that's really what we get out of that, is that he was real drunk, really, really drunk, but he was sobering up. So, okay. And really drunk, sobering up, he would have, the alcohol wasn't going to kill him, is I guess another thing.
Before you on the desk over there, laser pointer. If you could, Mark, that just been, if you could focus in.
Yeah, 0.3 is really smashed. Over 0.3 is basically where people start possibly dying or passing out. This is the situation where you could be in some serious trouble. So, yeah.
Top in the head. Now, Dr. Scordeballo, what's up on the screen? Is that what you have before you as the next exhibit?
Yes.
And on this, as far as the examination that you conducted, that also included certain measurements as far as height, weight.
Oh, this is an excellent point. Jack Druger says he wouldn't be sobering up in the minutes it takes to get from the waterfall to 34 Fairview. No, because we saw him drinking heavily at the waterfall. He would almost certainly have been still digesting booze and on an upward swing. So the fact that his blood alcohol is coming down suggests that maybe he had some time when he wasn't drinking. That, I think, is a really good observation. Thank you. So, yeah, that suggests that maybe he had some time in between his last drink and, But that said, that might have been the time when he was in the snow. Exactly. So, it's all interesting.
Like that you did with regard to Mr. O'Keefe's body, correct?
Correct.
And if you could, what did you record as your measurements for both height and the weight of Mr. O'Keefe?
He was weighed by our staff as 216 pounds and measuring 73 inches, which is 6 feet 1 inch.
So John O'Keefe was a big guy. John O'Keefe was a big guy, 216 pounds. And that's a big guy.
Now, Doctor, if you could, using the laser pointer before you, direct the jury's attention to, starting with the front or the facial area and then to the back of the head, but just with reference to the head area, directing their attention to what, if anything, you observed in the area of the head of Mr. O'Keefe.
In terms of injuries, you'd like me to point out the injuries? So as I mentioned, there were ecchymosis, that's another word for collection of blood under the upper eyelids. On Mr. O'Keefe, the ecchymosis on the right eyelid was also associated with a very small laceration. Then there was an abrasion on the left side of the nose. And then on the back of the head, there was a 3 centimeter laceration. So this is the right side. It would be towards, the back lower side on the right side of the head.
And that laceration on the back lower.
So I just want to note here, they're going to note all of these little injuries, and most of these injuries are little injuries. And what I mean by that is that most of these injuries are not injuries that would kill you. They're mostly injuries that would sort of cause you, the head injury is the big one. But other than that, and there's one big set of injuries, but there's an explanation for it. Other than that, it's like little minor abrasions. It's not anything super big.
Right side of the head, is that in the same area that you observed what you described as sort of the originating skull fracture?
Yes, when the scalp was reflected, there was bleeding under the scalp in that particular area. And then when the skull was opened, that's the area that appeared fractured and appeared to have other fractures originating or radiating from it.
Ms. Gilman, if you wouldn't mind scrolling down to sort of the middle of the torso. And Dr. Scordeballo, if you could again, using the laser pointer, just direct the jury's attention to what, if any, injuries you noted in this sort of middle torso or upper extremity portion of Mr. O'Keefe.
So on the right upper extremity, and again, this is the back of the body.
This is where you see
we
the
have
slashes.
this collection of linear abrasions. I think the battery is dead. That measured up to 7 centimeters and extended from the upper arm down to the middle of the forearm.
If I could interrupt you for 1 second, may I switch?
Thanks. This would be the abrasions.
Ms. Gilman, if I could ask you to scroll down for the lower extremities. And again, Dr. Scordeballo, if you could, again, using laser pointer, direct the jury's attention to what, if any, injuries you observed on the lower extremities in regard to Mr. O'Keefe.
The lower extremities didn't have a lot of injuries. There was a small abrasion on his right knee area on the side. And if you don't mind pushing the diagram just a little bit more up to see the hands, there were some contusions or some bruises on the dorsal aspects of the right hand and some very faint bruise on the left.
Thank you, Doctor. And Ms. Gilman, you can take that down. Your may approach again.
Yes.
Doctor, if I could show you what's a 2-page document, ask you to just review that a couple of minutes.
Yes,
And do you recognize what that is?
I do.
And what do you recognize that to be?
These are copies of diagrams that I used at the time of autopsy to document some of the injuries on the face and the skull.
May I approach again, Your Honor?
Yes.
I'm about to seek to introduce in the minutes the next exhibit.
Any objection?
No objection.
Thank you.
Exhibit 644.
And Your Honor, may I return that to the witness?
Yes.
With court's permission, if we could publish that for the jury.
Okay.
All right, so we get the picture of the skull and this very creepy picture of
One
a
moment, Your Honor.
featureless dude. It doesn't break down much after death. It'll be death is pretty much the stop on that.
Okay, Dr. Scordeballo, do you recognize what's picked up on the screen? It's the next exhibit for you.
Yes.
And if you could, again, using the laser pointer, direct the jury's attention to what, if anything, you observed or noted of significance in these particular diagrams.
So the upper eyelids, the areas of the upper eyelids on both sides had ecchymosis or blood. Under them, on the right side, there was a very small laceration or a small tear associated with that. Both eyes had some swelling.
Now, I thought that was really, really interesting. How does he get a laceration to the eye from this car accident? Because one of the things about your eyes is that they are recessed. Like if you press your hand flat against your eyeball or against, what you'll find is that you don't actually touch the eye much when you press something flat. So the reason why is that your skull kind of recesses the eyes. Now, where might you get a tear like that? Well, getting punched might do it. That might do it. I don't know, right? I don't know, but he's got a cut by his eye that seems weird, given that they're assuming that, in fact, he bounced with his skull off the ground. So that to me sounds like punched.
Them, and then on the nose there were
It takes a lot of swelling to
abrasions,
split
two
skin.
scrapes. One was small at 0.5 centimeters. The other one was 1 centimeter, and it was linear. And I noted them right there.
So he's got other abrasions to his face.
You're going to scroll down a bit. And again, from the bottom right diagram for you, Doctor, if you could, using the laser pointer, direct the jury's attention to what, if any, injuries of significance you noted in that portion of the diagram.
This is the area where I noted the laceration to the scalp. I noted something called tissue bridging, which is a morphologic feature of a laceration. Is what makes it different from an incised wound or from a cut, because again, the skin is crushed and now it's more irregular. The edges are more irregular. And then above that laceration, I noted that there was a scrape as well associated with it.
I bet Andrea Burkhardt has had cuts like that before. So, yep.
So that was one injury.
In this moment, if I could have the next page of that. Doctor, if I could direct you to the next page of that exhibit before you. And it's going to, if you could, then really sort of large on the top left diagram.
Yes.
Now, Doctor, before we get into the diagram that's up on the screen, if I could ask just a bit more, if you could expound upon when you use the term ecchymosis, what exactly does that mean in specific reference to the area of the eyes?
Ecchymoses are a word that we use to describe bruising. Orbital ecchymosis or periorbital ecchymosis or supraorbital ecchymosis just refer to the location of the bleeding in relation to the eye. And when we see ecchymosis or bleeding around the eyes, one of the differential diagnoses, one of the etiologies is blunt trauma to the head, and specifically fractures to what is known as the base of the skull. And this, what you're seeing here, is the base of the skull.
Now, Doctor, if you could, using that diagram up on the screen, explain to the jury, let me ask first, as far as what, were you able to formulate an opinion to a reasonable degree of medical certainty as to how the injuries within the skull and the brain interacted with each other, in particular interacted also?
So this is really, really tragic, right? This is really unfortunate. Yes, Amanda, we mentioned that. We did talk about that. This is weird. This is messed up. This is, yeah. Chelsea Ramos says, I thought I was going to miss the live tonight, but you're still going. Here's a super chat. That's a measly $1.25 an hour. It's all good. It's all good. Well, he doesn't, Ruckle. Keep up, lol. Fair. This is messed up. This looks to me like a, like a fist fight, but I'm not, she's going to say, I don't think it looks like a fist fight, by the way. I don't have
Once
a time.
the injury was inflicted.
For some reason, I forgot to get a timestamp for that, but she says basically, I don't think this was a fist fight. So.
And as far as anything related to footprints, drag marks, anything like that, did you observe anything like that in that area?
On the pictures that I saw, no.
So she says no drag marks. The thing is you're not going to get drag marks so much if he's wearing clothes, because clothes kind of, limit that.
Now, from your extent of your examination of Mr. O'Keefe's body, what, if anything, did you observe that would indicate any sort of altercation or a fight or anything like that Mr. O'Keefe was in?
Oh, here it is.
I didn't see any major signs of what I would call a significant altercation.
And with regard to that, as far as signs, what are some of the signs, and what would you be expecting to see, and what was lacking as far as your observations of Mr. O'Keefe?
I looked at Mr. O'Keefe's hands. As you saw in the diagrams, I did document that there were some contusions on the dorsal aspect, very vague and faint contusion on the left, and contusion on the right hand. That particular contusion has a central little pinpoint mark that may suggest that it was due to attempts to get IV access on his hand. That's a very common place, but I didn't see any bruising on Mr. O'Keefe's knuckles. His nails were intact. I didn't see any breaks on his nails, and I didn't see any fractures or feel any fractures on any of his hands.
Okay, so it's really common when people get into, there's certain kinds of injuries that they get. One thing is that most people don't punch right. Most people don't know how to punch right, and so they often break their hands in a fist fight. That is a very common injury. The other thing is that when you punch things, you get bruises on your knuckles. She's saying, that happens. But him not throwing punches doesn't mean he doesn't get punched, right? You can still get punched even if you're not throwing. And when they say he's got injuries to like the back of his hands, I'm wondering if that's like defensive injuries. So she says it might be because they tried to get an IV. Maybe it's because somebody was swinging at him and he's defending. The broken fingernails, by the way, is not typically, or usually you see that where somebody's trying to like claw and so forth. So yeah.
Now, with respect to...
And I got to do this. Michigan Farm Boy, thank you with the big 50 super chat there. The eye is also questionable because I took the theory from Commonwealth/Paul that John O'Keefe was hit from behind on his right arm, being spun and thrown, wouldn't tend to make a hard impact directly on the back of the skull or cuts to the eye. I mean, you can theoretically imagine the impact to the back of his skull, but it would be very difficult to imagine the impact to the back of his skull and to the front of his face at the same time. So, yeah, that's...
The diagrams that were up on the screen before, as well as your observations from internal examination. You observed some fractures to Mr. O'Keefe's ribs, is that correct?
Yes, he did have some fractures, I believe, to the fourth and fifth.
Women don't get taught how to fight
ribs,
properly.
Near the sternum. It's a very common location for CPR-associated fractures.
And so I believe you just alluded to it right there, but as far as any fractures to Mr. O'Keefe's ribs, what, if any, opinion do you have as to the origination or causality of those rib fractures?
As I mentioned, those are very consistent with the resuscitation. We see those quite often, given the history that I was provided that extensive resuscitation was attempted. I documented those as most likely due to resuscitation.
Now, doctor.
So this is really common. When you get CPR, you're probably going to end up with broken ribs. And the thing is that good news is that if the broken ribs bother you, then you're doing great for if you've got CPR, because it means you lived. But if you don't live, then you don't really care about the broken ribs. CPR should be, you know, if you're not breaking ribs, you're probably not doing it right. So that's super, super common. But there's other possibilities. Could he have been hit by a vehicle? Maybe. But she says that's probably not the cause. Could he have been worked over? Somebody gives him a boot when he's on the ground. Could that break his ribs? Maybe. But I suspect that this was just CPR. I suspect that this was just somebody, you know, trying to get him back moving, and wasn't working. So, you know, you keep doing it.
Hypothermia, you can see very, very red extremities due to vasodilation.
And with regard to the redness due to vasodilation, is there also a whiteness, sort of discoloration to the extremities that can be observed in hypothermic patients as well?
That's been described as well, yes.
Yeah.
Now, with reference to when you make your observations of Mr. O'Keefe, why is it that, well, let me ask you this. You didn't see any signs of vasodilation or white fingertips or anything like that, is that correct?
Correct. I rarely see signs of vasodilation, especially if someone has died in the hospital.
And can you explain to the jury sort of why that is?
So for two reasons. In this particular reason, Mr. O'Keefe was taken to the hospital and attempts were made at rewarming the body. So he was given warm intravenous fluids and attempts were made to bring the body temperature up with the hope that the heart would start working once that happened. Also, I did not physically see the body until Monday morning. And therefore, I can't really comment on vasodilation or any effects that hypothermia may or may not have had acutely on the body, because I'm seeing the body hours after death, and already the body has been transferred from the scene to the hospital, stored at the hospital, and then transferred from the hospital to our facility. So there's just too much time between when the body was discovered to when I looked at the body to make any reasonable comments on whether there was vasodilation or not.
Mayor Protron?
Yes.
She's not enjoying testifying either. By the way, they're not putting the pictures on, you know, I don't think that they're showing us the pictures, but they just handed the defense lawyers some pictures that look pretty gory. And I think this is where the judge calls it.
Doctor, I'm showing you a series of 5 photographs. Ask you to review those without them finished.
I'm actually going to see counsel at sidebar for a minute, please.
Oh, she's going to know it because that'll come up on cross. 100% that's coming up. Somebody says, does she normally speak with that pronounced accent? I'm sure she's not putting on an accent for this. So,
Having looked at the photographs, it makes sense that we break for today, and we'll start fresh with this tomorrow rather than showing these two folks now. So, thank you. So we are going to end for today. We are on track. We are definitely on track for finishing this case next week, partly because of staying all day tomorrow and some of the work we did today, and on Tuesday we will all do. So.
All right, so now she's sending the jury home. Great. That is it for today. I'm going to go through some super chats here. Galena Ward says, y'all are so rude. Ian is a Mrs. Runklesimp. Accurate. Loch Nessie, another hot mic moment today. Fuck under Lally's breath shortly after the ME was describing hypothermia and length of time. What do you think? I didn't hear it, so maybe. Wendy Wilkinson, find it interesting ME was filling in at the Cape Cod office, so not the usual ME for Proctor at all. Hence comments regarding manner of death and whack job. Maybe. Might be. Might be that their normal person just does what they say. Gloria Marseg, thank you for the super sticker. Debbie W, 6'2", 220 pounds, is the cannon size of Steve Rogers. Captain America, okay. Annabelle Feinstein, please show the tweet from Gordon Ramsay and compare it to John O'Keefe. I'm not going to do that because I might get hit with a copyright thing, so I'm not going to do that. You can look that up yourselves, guys. Gordon Ramsay was hit by a car. He's got a horrible, hideous bruise that John O'Keefe doesn't have. So, yep, it's exciting. Misty Harris, Emmy said there wouldn't be much external bleeding from the head wound. So where did all the blood in the solo cups come from? Not much means at least, I mean, there'd be some. John Beattybot, could Little share rookie move text on cross? Absolutely. I suspect that they will. I suspect that they'll present to the ME, did you get pressured? Did you get told to, what you should and shouldn't say? That'll be there. So tomorrow, we're going to see a whole bunch of stuff. I probably won't get to cover that in the evening because I suspect there's going to be Friday Night Frenzy. If there is no Friday Night Frenzy, then I'll do a stream. But if there's going to be Friday Night Frenzy, I'll probably be on that. I will probably do a recap stream on Saturday to cover tomorrow's testimony because, all right. Unless there's any sort of last minute questions, last minute super chats, anything else like that, I will wrap up. I will wish you guys all a wonderful evening. I am who runs Friday Night Frenzy? Law and Lumber. It's on his channel. So go check that out. We're usually there talking about fun fun things in law and so forth. So we'll talk soon, and thank you guys all for joining me. I really do appreciate it. I couldn't do this if not for you guys, and so love having you here in the chat. And as always, have a great night, and we'll see you soon. Okay.